So a young lawyer was applying for a job at a very esteemed legal firm, and one of the directors said to him, "I'm going to ask you a very pertinent question. It's very important when it comes to our career." He said, "How honest are you?" And the young lawyer thought about it and he said, "Well, let me tell you about honesty. My father borrowed me $85,000 so that I could finish my legal degree, and I paid him back every cent after I settled my first court case." The director said, "Well, that's pretty impressive. What was your first case about?" And he said, "Oh, it was just my dad who sued me for the money." I couldn't let a legal joke slide with a panel full of lawyers. So, good morning, everybody. Welcome. My name is Jacques Bredrijk. I'm the campaigns manager at AfriForum. And although humor is a great way to break the ice, today's topic is no laughing matter. Corruption, nepotism, cadre deployment, and a general apathy towards abiding by rules and regulations has led to the decline of every state organ in this country, and unfortunately that includes the legal system as well. But hopefully after today's discussions from our amazing contributors, we'll have a better understanding of how we can tackle these challenges going ahead. So I'd like to start off by welcoming a man who needs no formal introduction, Advocate Gerrie. Let's please give him a warm round of applause. Thank you.
Amazingly, this is a show, isn't it? The announcement said, "Please be seated whilst the show is on the go. Don't leave whilst the show is on the go." A couple of months ago, I was in Imathatleni, where I addressed people, and it happened at a church. So they asked me to do this from the pulpit. My mother would have been so happy, because she also wanted me to be in church on a pulpit. And now I'm on stage. Nobody would ever have believed that Nell would end up on stage. People that, I know a long time, like Professor Koos, he would tell you that he never thought that we'll end up on a stage. But let me start. Knowing that I'm in the presence of esteemed academics today, I decided to National Director of Public Prosecutions, Advocate Pikoli. Advocate Pikoli informed Mr. Mbeki that the National Prosecuting Authority, I'll refer to them as the NPA, has decided to prosecute Mr. Salebe for corruption. The President was displeased, and he requested that the decision and prosecution be held in abeyance. So just think for yourself, the President asked the National Director just to hang on with this prosecution. Mr. Pikoli refused. Mr. Pikoli said it's his duty to prosecute. I said, "It's the court's view that the version of Abrams and Mogatle raises serious questions of credibility." Just think back about the Advocate van Leeuwen and Volkow and Advocate Pikoli. The court continued saying, "Thirdly, the explanation given by Abrams and supported by Mogatle to the effect that the decision to withdraw charges purportedly taken by Mogatle was disguised as a form of recommendation so as to avoid it being leaked is bizarre in the extreme. To opine and make recommendations which later turn out to have been disguised for the decision is disingenuous and lacks integrity." That's what the appeal court said. In a minority judgment in the same court, Judge Wright, I just want to read it to you because, courts have a way of putting things. He said, "In my view, the decision was taken by Mr. Abrams. I make no adverse credibility finding against either Abrams or Mogatle," but now listen to this. "I simply prefer my interpretation of the facts and the law to theirs." What has he said? Just absolutely brilliant. We have now, in that particular matter, applied for a nolle prosequi certificate to privately prosecute on behalf of General Booysen, that can unfortunately not be here today. Now, for me, this third degree of comparison is the regressive superlative degree of comparison. I reiterate, it's my perception of the 3 prosecutorial incidents over years, and this is indicative of the moral high ground once held by the NPA, and then its implosion thereof by the third unequivocally regressive superlative degree of comparison. During a discussions with Karima Brown on the 20th of March 2020, Advocate Betoy discussed, and these are her words, the broken and factionalized NPA she inherited. And going on to state that her biggest challenge was whom to trust in the NPA. Let it just sink in. In March 2020, the National Director of Public Prosecution indicated on public TV that she didn't know, she couldn't trust her prosecutors. My intention today is to share my practical experience of the dysfunctional criminal justice system and not to comment on Advocate Betoy's stated intentions to correct the NPA. However, what needs to be said is that every new appointee is always allowed a honeymoon period to find their feet and to see what impact they can make, as was afforded to Mr. Abrams. Can we just have the second video?
The days of disrespecting decisions of the National Prosecuting Authority are over. The days of looking at the National Prosecuting Authority in such a light are over. The days of non-accountability and not holding senior government officials accountable are over. I hope your question's been answered.
Has it? I hope your question's been answered. But Advocate Betoy was as unwavering as her predecessor, Mr. Abrams, that she would not bow to political pressure. But her actions to prosecute Mr. Ace Magashula, which is correct, she should. I mean, we have a team of prosecutors and a team of FBI investigators in America as we speak. They were there 2 weeks ago. It's contrasted by her absolute inaction to prosecute Mr. Mbalula on charges of corruption and Mr. Malema on charges of corruption and fraud on point, and then the peculiar prosecution of a whistleblower in the state capture. This all speaks for itself. Now, mindful of the source of the information, I foresee very peculiar, and to my mind, politically motivated prosecutions as imminent. So if it happens, just think back on what I said. I expect it just after the elections. Nothing will happen until the elections on the 1st of November. This conference had its birth when I shared the frustrations we have with the criminal justice system during a meeting with the directors of AfriForum. I not only say, but will confirm my view with practical examples that the NPA and SAPS, South African Police Service, I refer to them as SAPS, will avert the prosecution of friendly political comrades of the current regime. They will avoid politically inopportune prosecutions, even at the cost and detriment of the integrity or the trust society must have in them. The NPA never fails to find particular and irrational reasons to tender as an excuse for establishing the impossibility for them not to prosecute political figures against the will of the ANC. I refer to cases against Mr. Malema, Mr. Balula, and Masjiba as we go on. So they either have to follow their master's voice, or they must admit, and then we have to accept, that they do not have the necessary competence to prosecute complicated matters. If so, we do not have to convince anyone that the criminal justice system has imploded, if they make that. So it's either they follow the master's voice, or they admit that they just cannot do it. There's no other option for them to elect. Let me focus on the purpose for today. Firstly, I reiterate that I will share with you practical examples of matters in my office. I select only a few. We have very, very many examples that one can use. But this is only an amplification of the collapse system, but also an indication of the steps we have taken to ensure that the system does not remain dysfunctional and ultimately crumble any further. We are not convinced that the existing system with the current incumbents is salvageable. But it's what we have at the moment. We will later on discuss in more detail alternatives to refloat the sunken ship of justice. Please bear with me. The context of the issues that I will discuss will become clear from our office's practical examples of interventions to force the NPA and SAPS into doing their duty. The NPA and SAPS have become accustomed over the year to frustrated complainants that lose hope and then abandon their quest for justice by forsaking their complaints. You've all heard that. we just cannot do it anymore. It's either we give up hope or we run out of money. But we just cannot get the MPA and the SAPs just to do their duty, not more than that. However, the structure of the prior prosecution unit and our understanding of the inner workings of these departments establish an ability to act on behalf of clients and thereby persuading departments to deal with these matters ultimately. For me, the straw that broke the camel's back was a letter we received from the South African Police Service on the 27th of May, 2021. We've all heard, and you've heard in the media about the discussions about the South African Police Service's backlog in analyzing DNA evidence, but this is to follow my distorted understanding of degrees of comparison. And please don't look at Andrew, he won't like what I'm saying, but this is even worse than we've discussed with you. Because the police wrote to us officially saying, follow-up was made to secure the ballistic reports, but in vain. It's a murder matter that happened in 2010. So we got involved, we just want to know what happened to that murder matter. So they say, follow-up was made to secure the ballistic report, but in vain. The reason from forensic science is that 2010 ballistic reports are kept somewhere where the police are no longer having access to the building. The lease were not paid and there is a dispute. There is no guarantee as to when the dispute will be resolved. So we have to accept the police cannot access their case dockets and their reports to deal with matters. We've also heard a Deputy Director of Public Prosecution inform us proudly that he cannot deal with our inquiry at the moment because he hasn't been at the office since January. How can I deal with the matters allocated to me if I haven't been to the office since January? A senior advocate informed us in an email on Friday, this Friday, indicating he wrote a letter to Heidi saying, I cannot access the files, the files are kept at administration. How do you expect of me to go to administration and get the files? We have it in writing. So I say the members of the public should not be concerned or bothered with the MPA's peculiar or collapsed administrative system. They should just show some pride and some professionalism to deal with these matters. A senior state advocate informs us that she cannot give attention to a specific matter, ShareMax, because she's been allocated another matter. How can I now deal with the other matter? I'm dealing with ShareMax, and that's all I can do. Now, we say there's absolutely no contingency arrangements. That's a management issue. And there's no professional commitment and pride. I just have to share with you that I am aware of numerous senior people in the NPA that have not been at the office since lockdown in March 2020. They've been at home now for more than 550 days. Now then, put it into perspective that we cannot access files because files are kept at the administrative section at the office. So how can you deal with this matter? I've now heard that the MPA decided people have to come back to the office, but only every second day. And I'm thinking, how is that scientific? Is that the virus? Why would people be required to go back every second day? I think it's just a difficulty of getting people in the NPA back to work. Let me deal with the Fourie private prosecution. Now, I'm very glad to say our complainant is with us. Mr. Fourie is with us, so I'm going to point him with this pointer you see there. Can you raise your hand, Andre? There's Mr. Fourie. He's our complainant in this particular matter, and let me share with you the matter. The reluctance by the MPA to prosecute or issue a knowledge certificate can only, in this matter, have a political motive. Let me share with you the facts. A made the false racism allegations against Mr. Fourie. A opened a criminal case against Mr. Fourie for having used a derogatory word. And you all know which derogatory word I refer to. A said Mr. Fourie used the K word. When they wanted to see, the police wanted to see him and arrest him, he consulted with us, and we immediately realized it's one of those matters where we can prove that it never happened. We opened a case against A. Mr. Fourie lost his job because of this incident. The state refused to prosecute. Just think for yourself, have you heard of a matter where the state refused to prosecute somebody that used the K word? The answer is just no. But in this particular matter, they refused to prosecute. But let's go through the process. Firstly, the state indicated to us that they have no record of this matter, having knowledge. So what I'm sharing with you is just the delay built in the system of the MPA not dealing with matters. Firstly, they indicate we don't have record that we decline to prosecute. Secondly, they indicate to us that the docket is missing. You won't believe it, but in every application that we have, they indicate to us that the docket is missing and that the investigating officer is still searching for the docket. But I see Mr. Spies here, so there's lots of hit and Spies letters that we use. But what we've done, we've become accustomed to the police losing case dockets. And so we keep copies of those case dockets. So we were able to write to them and say the following. We are suspicious that both dockets have gone missing, especially when taking the nature of the matter into consideration. Having had experience in the loss of dockets to either explain an undue delay or to avoid prosecution, we have copied the dockets and hereby make them available to your office. So that excuse was not available to them anymore. We made copies of the docket available. I forgot to introduce Phyllis Foster, advocate in my office. You know, if you're as old as I am, you can do nothing on your own. And if you're a man, you can do absolutely nothing with lots of documents without a woman to direct you and pass you all the documents. So that's why Phyllis is here. And obviously, and I have to say that I'm sharing with you what the office is doing, but I'm just a passenger. It's done by everybody in my office. They do all these things, and I get opportunities to stand here and to tell you, and to tell you that I've did it all myself. They help me nothing. So we sent them a copy. They delayed the decision, and they eventually indicated that they've decided that it's not in the interest of justice to issue a certificate. Now, you're not all lawyers, but that's not one of the factors that they should take into account. They have absolutely no discretion. The only discretion the MPA will have is to prosecute or not. If they fail to prosecute, they have to issue a non-prosecute certificate. That's the law. Now, at the DPP's office in Pretoria, they say, this office is of the opinion that justice will not be served to issue a non-prosecute certificate. It's absolutely ridiculous. And we'll carry on throughout what I'm trying to share with you. We have to approach court and the High Court through mandamus and applications just to get the NPA to do their duty. It's not only a huge cost burden, but it's a burden of time. And it's as if somebody, in whatever career you're in, tells you that today is Tuesday. And you just know, but it's not Tuesday. But then you have to approach the High Court to just convince them that it's not Tuesday. We informed them that they're wrong in law. We indicated to them that they don't have a discretion, and this we did in a letter. Okay, now I can't find it. But so we informed them that we say, and I have to stand here, as you see, I can't see there, I have to read here. This letter is consequently addressed to your office to reiterate that the refusal by the DPP to issue the certificate in favor of our client is not only untenable in law, but seriously prejudicial to our client's prospects to privately prosecute and seek justice in his personal capacity. It is strongly contended that the DPP overstepped the bounds of its discretion by refusing to grant the certificate to our client. So what we try and do is just try and tell them that you're wrong. Just let us fix it up and let justice prevail. Issue the certificate because it's your duty to do so. We then continue. In the light of the fact that the certificate was requested as long ago as 25 October 2019, we request that the relevant decision be reviewed as a matter of urgency. So that is Mr. Fourie. Now, if you ask me why they would do this, my inference is that they know that the refusal to prosecute is irrational and politically driven. They just know that. So they know if they issue us a certificate that we have a very good chance of a successful prosecution. Otherwise, why would they not issue a not a prosecute certificate? They also realize that they will look terrible if we successfully prosecute. We reported the delay and their irrational decision to the National Director of Public Prosecutions on the 1st of April 2021. Needless to say, we haven't had a response from her office. So we're in the process of filing papers in the High Court just to force them to do their duty. Let me now deal with the prosecution, or well, the case we have against Mr. Mbalula. Background: Monique Tauter reported the case of Mr. Mbalula's peculiar holiday to the Public Protector in 2017. The Public Protector advised the MPA to investigate the allegations of money laundering. We don't agree that's money laundering, we think it's more corruption, but be it as it may. There's a report from the Public Protector to the MPA, investigate this matter. Nothing happened. Because of the delay and nothing happening, we opened a case docket on the 6th of August 2019. So we opened the case and then informed them that we've opened the case. So, having opened the matter, as the complainant, you from time to time must get feedback from the investigating officer. So the investigating officer has to tell you what happened, and they did. But you won't believe it, but the investigating officer would travel all the way from his police station to the AfriForum building to tell Monique the investigation is continuing. That's it. That's all. Not what they're doing, what is outstanding, why it can't, just the investigation is continuing. So we thought that it's the investigating officer, and we reported his conduct to the national head of the DPCI, Directorate for Priority Crime Investigation, also known as the Hawks. We say that he informed her that the reasons for the phone call was to provide feedback regarding investigation into a complaint. His feedback was that the investigation was ongoing, but he was unable to indicate to her what exactly was outstanding. We say such feedback regrettably falls short of any meaningful construal of the available evidence, outstanding investigative tasks, expected timelines, and possible difficulties in gathering evidence. We continue, and we say the following. So we write this letter to the head of the Hawks. We say, we're of the view that this feedback was merely a tick box exercise by the investigating officer. Regrettably, there exists no indication that any meaningful progress has been made. Now, the time we wrote this, remember we said we reported it to Public Protector in 2017. We opened the case in 2019. This is April 2020. Absolutely nothing's happened. So we continue by saying, the suspect identified is not merely a person that transgressed an emergency regulation by selling mealies to stave off the hunger plight of his family, but rather a notable and outspoken politician. Remember, during that time, they arrested people that sold mealies next to the street because there was emergency regulation, so they would much rather do that than arrive there with tens of policemen to arrest poor people. So we carry on. We say, having followed the Zondo Commission, where years of ineptness by law enforcement has come to the fore, The irresistible inference is that despite lessons learned, the handling of our client's case may be a repeat of the unwillingness or inability of the SAPs to deal with high-level corruption. Isn't that strange? I mean, that's what we hear. We all sit and watch the Zondo Commission, and everybody goes there and say, we've made mistakes in the past. But we see those kind of mistakes just repeated. We are concerned that this continuing pattern of certain prominent political figures being sheltered from investigation and prosecution seems to be continuing. So we have a commission, we have Zondo, we all feel good about Zondo, but if you try and prosecute somebody that's not out of favor, you have exactly the same difficulty. So we open a case docket, we wrote to, so then we wrote, because we received the following response from the head of the Hawks. So you've seen that long letter we wrote to the head of the Hawks. The head of the Hawks sent us a 4-line letter. Progress will be reported directly to the complainant by the investigating officer. That's it. Hasn't dealt with anything. He hasn't said that they're investigating what they're doing. He said it will be reported. So when we received that, we thought, let's write to the minister. You all know Minister Kele. Obviously, he will take immediate action, and this matter will be driven in a direction. So we wrote to the minister, and we complain about the head of the Hawks. We say that the head of the Hawks' response is dismissive and lacks substance. We are flabbergasted that the head of the DPCI would sign this document as an official response to a complaint in such a serious matter. We proclaim that this matter has more substance than arresting people that walk on the beach. Remember who arrested those people that walked on the beach? Can you still remember? The minister himself, with people around him with long rifles. We say society demands that matters against high-profile politically connected individuals receive the attention it deserves, while SAPS's comportment suggests a contradictory view. We carry on, and I have to read you all these letters, everything we write, because that will give you context and also indicate to you what we have to do just to get SAPs to do their duty. Paragraph 16, we say, we discussed the connecting the dots. I mean, you all remember what happened in the Zondo Commission of connecting the dots and the whole debate. We say the phrase connecting the dots is similarly pertinent to this investigation, and we have to believe that the skilled investigators of the DPCI are capable of connecting the dots already identified by the Public Protector's report. With the Public Protector's Office having outpaced the DPCI investigation, the inference is tenable that there exists either an inability or unwillingness to investigate this matter. The conduct of the Hawks may also be a mere disregard for complainants and society as a whole, thus discarding any hope that justice is not only done, but also seen to be done. We continue by saying, if delays are allowed to continue, it will only add weight to the perception that not everyone is equal before the law, and that certain prominent political figures are sheltered from prosecution. And then we carry on by saying, it became apparent during the proceedings of the Zondo Commission that the reluctance of law enforcement to fulfill their duty without fear, favor, or prejudice was a factor that contributed to state capture. We are well aware of the criticism leveled against the DPCI under the previous command and confidently anticipated different handling of this matter under new command, only to have such hopes dashed. Now, if you're the head of any organization, and I mean, we have Mr. Spies, we have Mr. Booysen, we have Mr. Creel, your response would be something like this. So we have the response by the minister. Our office will provide the necessary feedback once there is any progress. Not what they're doing, not that they will ensure that it happens, not that we will provide you with feedback. We will provide you with feedback once there's any progress in the matter. So that is the minister. So So now we wrote to the head of the Hawks. We wrote to the minister. Nothing happened. So we thought, let us now write to the head of the Special Commercial Crimes Unit of the MPA. So we did. We wrote to the head of the SCCU, and we say that almost 2 years have passed since the matter was reported to the police. During this period, the investigating team had access to the Public Protector's report, setting out all the facts whilst providing names of all witnesses, and we have made little progress. Just think for yourself, there's a Public Protector's report with all the witnesses, all the evidence. That's handed over to a policeman, and there's absolutely no progress. Then, if you had hopes that there will be lots of prosecution from the Zondo Commission, the exact same thing will happen. They will hand over the Zondo Commission's investigations to a policeman that will have to investigate and get the matter court ready. Why would we expect anything else to happen? We say the irresistible inference must be that either the DPCI are reluctant to investigate the matter against the cabinet minister or incapable of investigating allegations of a minister that may have received a holiday as a benefit from a known service provider. We continue paragraph 6. We are concerned that this pattern of certain prominent political figures being sheltered from investigation and or prosecution seems to be continuing. We have noted the political fallout with the arrest and appearance in court of Mr. Magashula and cannot be blamed for inferring that the delay in this matter may be dictated by the suspect's political affiliation. Why else would that happen? We then continue by saying, it's in the interest of the complainant, the alleged suspect, and society to expect that the case be dealt with expeditiously and proficiently. And you all are now waiting to say, what did they respond? They solved this matter. We wrote the letter, the MPA jumped up, and they fixed this. No, they haven't. We received the same response from the head of the SCCU. I'll read it to you. The investigation is continuing. You will be notified if there are changes. That's the MPA. They have to ensure that a high-profile matter is brought to court. You will be notified if there are changes. So, I often wonder if the position of Mr. Mbalula as head of the elections in the ANC, if it's got anything to do with the apparent reluctance to investigate. But let us deal with another matter. I'm going to share with you a couple of matters, just so that you get an idea of the attempts we put in to ensure that the justice system functions, and then later we'll share other initiatives we have taken. On point, Mr. Kriel is the complainant in this matter. The NPA decided to prosecute Mr. Malema and enrolled the matter. Remember, they enrolled the matter. It was in the High Court in Polokwane. The matter was struck off the roll because one of the accused fell ill and he couldn't be at the trial. So the matter was struck off the roll, and this happened on the 4th of August 2015. 4th of August 2015, the matter was struck off the roll. We then made inquiries. We first established that this person that was so ill that he couldn't proceed with the trial, through the brilliant work of the investigators in the office, they established, using Facebook and all this kind of available information, that he was now well. So we wrote, said, we've now established that the accused is well, and this we did on 19th of March 2018. Now, just think for yourself, if we did not get involved, this matter would have been forgotten. Because nothing, absolutely no inquiries were made by the NPA between August 2015 and when we got involved again in March 2018. There were lots of things that happened, meetings. The NPA met with Mr. Kriel and I, wrote lots of letters, and then because of the unreasonable delay, we said, we're now filing a mandamus, and we did. We filed a mandamus. A mandamus is a process where you force the NPA or any government department, any person with authority, just to do their duty. That's all. In terms of mandamus, you say, just do your duty. Just take a decision on this man. We're not dictating what decision you must take. Just take a decision. So we filed the mandamus, and then we got action. When we filed the mandamus, they indicate to us that they have now responded. They send a letter to Mr. Creel on the 15th of November. They tendered cost and asked us to remove it. So successful mandamus with cost we got from the NPA. But what did they do? They informed us that they've decided to prosecute the directors of On Point and not Mr. Malema. That's the easy way out. One thing also, they decided to prosecute a person that passed away. But they later fixed that because it just indicates you how they looked at the matter to prosecute somebody that passed away. So they indicated that they will only prosecute On Point and the directors, but not Mr. Malema. We indicated to them that it's irrational. If you're dealing with a money laundering matter, and then you should have both parties before court. It serves absolutely no purpose to prosecute the directors of On Point and not Mr. Malema. We received no meaningful response from them. We indicate to them in a letter the failure to prosecute Mr. Malema and Mr. Mgwangwa together on charges of money laundering in the main trial is irrational. Likewise, the late investigation into the administration of the Ratanang Trust in circumstances of the flow of the money is clear, is undisputable. So we indicate to them that we don't know why you're delaying this prosecution or why you've taken this decision. The NPA then eventually informed us that they've decided, firstly, you have to follow this all. I know it's difficult to follow, but just think how frustrating it is to drive this process. So it's difficult for you to follow. So we make representations saying that it's irrational, it's illogical, you can't do it. You know what the response is? From the Deputy National Director of Public Prosecutions. He's saying, okay, we've decided to further investigate. So we, after careful considerations of the information made available to me, I've decided that a certain outstanding investigation must be conducted, and once they are completed, the decision regarding the prosecution of Mr. Malema or not will be taken. So now they had to do further investigation. And we again approached the Director of Public Prosecution. We wrote a letter to Advocate Shamala Batoya herself, and we said that it doesn't make sense to not prosecute. Sorry, I have to look back. You see, if you get as old as I am, I can't read there. I've got glasses that can read there, but then I can't read here. So I'd much rather look at all these documents and be able to read them. We indicate to Advocate Batoya, we unavoidably must now revert our request to you, as more than a year has passed since we made our representations. The perfunctory responses by Advocate Cook we submit indicate the continued lack of resolve and indecision to prosecute Mr. Malema in a hope that we will go away. So that's what we do in all the matters. We just tell them, please don't think we'll go away, because we won't go away. Remember, when I started, I said that's what happens. The police have become accustomed to the fact that people will just go away. They just cannot take it anymore. So we say to them in writing that we will not go away. Then we received a letter from the NPA on the 7th of April 2021, where they say the following. They say they're investigating. Remember, they said they're investigating the further aspects. They say the nature of these investigations will delay the prosecution in the On Point for several years. I therefore agree with the Director of North Gauteng that the prosecution in respect of On-Point Engineering and its directors should proceed as a matter of urgency. Now, just think for yourself, if you're doing this like we do daily, then you know what they're saying. What are they saying? We're incapable of investigating this matter at a pace that we can prosecute. We would much rather have this matter prosecuted with all the accused there than waste time, than do anything to have this matter prosecuted. So, and then, I know you're tired of me reading all these letters, but we have to write them. This is what we have to do to get the matter before court. Now, we're structured to do this. I'm sharing it with you because not all people have access to an office that is structured to do all this. There are thousands of people that just give up on justice. And why? Because of the collapse of the criminal justice system. So, we then wrote to the National Director of Advocate Batoy herself, and we say, undoubtedly, the facts presented to the... So, now we just summarized everything. Remember, there was a prosecution. There was also an asset forfeiture application on the farm, which was successful. The National Director at the time signed a certificate, the racketeering certificate. So I have to explain this to you. If you want to charge somebody for racketeering, the National Director of Public Prosecution herself will have to sign a certificate to enable you to do that. In that certificate, the National Director indicates, I have perused the facts and I'm convinced that there's a case and they should prosecute. So that happened in 2012. So we then write to her and we say, undoubtedly the facts presented to the then NDPP in 2012 caused him to issue a racketeering certificate. The very same facts caused the High Court to grant a forfeiture order in December 2012. If it was then argued by the NDPP during the application for forfeiture order that the farm was purchased with the proceeds, then the argument should remain the same. I mean, that's logical. If in 2012 they were successful, nothing changed. The nature of the proceeds never changed. So we say that. We stand unpersuaded that the facts have changed since 2014, but understand that the political landscape may have changed. Therefore, the irrational decision by Mr. de Kock to require further investigation only as far as the case against Mr. Malema is concerned, as it is at best unwarranted, an unwarranted delay of the prosecution. So, having done that, we received a very short letter. I've been reprimanded. Which one did I skip? I never read 14. But aware of the NPA was ready to proceed with the prosecution in March 2014, we have to accept that the prosecution team consulted with all the witnesses and was confident to proceed with the prosecution. The prosecution vehemently opposed the postponement and even briefed private counsel to argue for the matter to proceed. Now, I have to just tell you what happened. In 2014, when one of the accused fell ill, the NPA wanted to proceed. They appointed a senior counsel from the bar to argue on their behalf for the matter to proceed. Now, 6 years later, they say, we don't know if we have enough evidence. What happened in the meantime? Absolutely nothing. It's just perhaps a change in the political landscape. We then, in the end, received a very short letter from the NPA indicating this seems to confirm, after consultation with the National Director, that the prosecution on On-Point Engineering and its directors will proceed separately to avoid any further delays whilst outstanding investigation in respect of Mr. Malema and the Rattanang Trust is being conducted. This is an admission that they're incapable of getting this matter before court. It can be nothing else. It's not an indication to us saying, you're wrong. It's just an indication of saying, we're incapable of doing this. So, we're almost done. Let's deal with Sharemax. Now, in Sharemax, there are two issues at play. It's a contravention of the Bank Act, which is a criminal prosecution, and then an asset forfeiture application because the assets procured through the Sharemax scheme were the proceeds of crime for purposes of the poker legislation. Now, let me just start by saying years went in, lots of letters went in, and now, in the last month or so, they admitted that we are right, that those were proceeds of crime, but they're still not proceeding with the asset forfeiture application. So, let me just run through it. The NPA decided to prosecute this matter, to prosecute the Sharemax matter on the 14th of December 2018. Now, when did they decide? December 2018. Yeah, they've already decided to prosecute this matter. Nothing happened. They never formally made it public. We drafted an asset forfeiture application. We presented that asset forfeiture application to the NPA on the 27th of June 2020. Now, let me just interrupt myself. So, because of the structure at our office, we have the skills to draft asset forfeiture applications because the people we appointed did that for the NPA. So, knowing all the facts and having the skills to draft the asset forfeiture application, we did so. We drafted the application, we handed the application over to the NPA and said, all you need to do is to take this through court. They responded by saying that they don't believe that the assets were the proceeds of crime. They say because of what happened with Nova, it's very complicated, and please, I don't want to complicate all the issues, but Nova was a special purpose vehicle that created where the assets on Sharemax were handed over to Nova, and you know what the NPA and seemingly senior counsel indicated? The mere fact that the assets that were procured in contravention of the Bank Act, because it was later handed over to Nova, it affected the nature of the assets. I mean, everybody's looking at me with no. I mean, if you have proceeds of crime and you hand it over to somebody else, it remains the proceeds of crime. For us, it's so logical. To try and convince the NPA that it's so is impossible. But it's not only the they say to us in a letter, and that letter was, let me see, in 2020, July, they say to us that because of Nova, the Nova scheme, as a result of this appears to be no illegality, as the companies and the underlying assets taken over by Nova complied with the Bank Act and can therefore not be regarded as assets acquired from the proceeds of crime. So, it's very difficult, and I know, this is very technical, but my duty today is just to indicate to you what we have to do to convince the NPA just to do what they should do. Now, then they indicate to us, please bear in mind that nearly 10 years has lapsed since the creation of Nova, which inevitably complicates the matters further. I mean, that's what we've been saying, that you've been doing nothing, and that we've given you an option to just bring an asset forfeiture application. We indicated to the NPA that we think that their failure to act is irrational. What they then did is they wrote this letter saying they now have an opinion by senior counsel. And that opinion by senior counsel, opinion by senior counsel is the following. Senior counsel wrote them an opinion, and the opinion reads something. The conduct of Shemax appears to render the property proceeds of unlawful activities for purpose of Section 38 of the Prevention of the Organised Crime Act. Now, this letter was sent to us on the 4th of May, 2021. So after years, they say, we now agree with you that the property acquired through the Shemax scheme qualifies as proceeds of crime. So the illegality principle is now gone, but then they say, for purposes of what the senior counsel said, the senior counsel apparently said, however, and based on the available facts and documentation, the NOVA scheme of arrangement, as sanctioned by court. Now, they really say that if something is sanctioned by court, it changes the nature of the proceeds, which cannot be. But it makes NOVA legal until set aside. But we say we've got nothing to do with NOVA. We're just dealing with Shemax. And we just cannot get that through to them. But then they indicate to us, for these reasons, I'm advised against proceeding with any Chapter 6 civil recoveries. I'm further advised that any possible Chapter 5 criminal recoveries are dependent on, inter alia, the SA Reserve Bank proceeds with their criminal if the SABC proceeds with a criminal complaint against Shemax. Now, we then again wrote to the MPA saying that they're wrong, and predictably we've received no response. Masjiba. Now, the matters I'm sharing with you are just matters in my office. It's not, we haven't scouted for matters. We haven't asked people to give us matters. It's matters that we have on our books. 10 people at AfriForum that created an office for prior prosecution. We sit with these matters, and this is what we have to do to get these matters through court. Now, the prosecution of Masjiba. Mr. Abrams' first major decision was to withdraw the case against Masjiba. You've seen that. That he did on the 18th of August 2015. We applied for a nollie prosecute certificate on behalf of General Booysen on 16 November 2017. On the 21st of December 2018, the High Court ordered the enrollment of the matter. I read it to you. There's a court order ordering the NPA to enroll the matter, and I hope we'll discuss it a bit later. But what happened here? There's a court order saying enroll the matter, and then we have the head of the NPA referring the matter to another person in his office to decide to prosecute or not. So the first thing and the last thing Mr. Abrams did in his office, the first thing he did was withdraw the charges. The last thing he did before he vacated his office was to, again, nollie the prosecution against Masjiba. We opened the case docket for the defeating the ends of justice and contempt of court. I read the appeal court decision to you. We demanded the enrollment of the matter, and then we threatened them with the mandamus again. So we've been successful once, and in this mandamus, just one back. Okay. So they say, because we threatened them with the mandamus again, Advocate Betoy sends us a letter saying the following. You can't read it and I can't, but the first paragraph reads, I agree that this matter has an unfortunate history and the delay is regretted. Then she says, I've impressed upon Advocate Beloy to expedite this matter. In the circumstances, any application for a mandamus will be premature. So, she was right, because we received a letter from Advocate Beloy saying, we've decided to prosecute Masjiba. And we were happy with that, because there will be a prosecution. But then they did a spectacular volte-face. A month later, we received a letter saying, we acknowledge that we've indicated that we will prosecute, but we now still have to look at the Mokgoro Commission's evidence. What changed? Absolutely nothing changed. The court ordered the re-enrollment. Now they want to further investigate and look at the Mokgoro Commission. So it's a spectacular volte-face by the same person who indicated that they will prosecute. Then the NPA, in an endeavor not to prosecute, played their ace. They referred the case to the investigating director. Said, the investigating director, please be advised that no certificate nolli prosecute can be issued at this stage as the matter remains subject of investigation. Why the ID, investigating director, would now even think of a nolli prosecute, because they don't issue a nolli prosecute. Why they would tell us that they're not issuing it, if it's not their duty, we don't know. But it's now been referred to the ID. And let me just make it clear. I'm critical about the effectiveness and the willingness of the ID to investigate or prosecute any matter. I'm critical of their approach to prosecution, and it became apparent. I have to read this, and if you have to listen to something, it's this paragraph. From the director of the investigating directorate, she writes us, as you must appreciate, these are extremely serious allegations that impugn the credibility of senior members of the very institution charged with upholding law, and they deserve to be fully ventilated. So, don't fear. When your matters get there, we won't really ventilate them. But because it's members in the MPA, it needs to be fully ventilated. This is years after the order by a court to prosecute. Now, I've indicated that I'm critical about their approach to prosecution because she makes it clear. The decision to prosecute or decline to do so is the product of prosecutorial judgment informed by the facts and the law. A measure of professional skepticism is also appropriate. Please be assured that the investigating directorate is pursuing all reasonable lines of inquiry before making a decision to prefer charges, and is doing so mindful of the urgency of this matter. And if I tell you that this letter was written on the 14th of March, you will tell me that we've received lots of responses since then, which is not so. I mean, the urgency of the matter. So that is the Masjiba prosecution. We don't think that a mandamus is premature at the moment. We will have to file our mandamus, we have to force them. I can see you all falling asleep, so I'm just going to deal with one other aspect. And then I'll end off, and we could perhaps discuss all this in a panel discussion, which I'm really excited about, to be in a panel discussion with esteemed jurists as a prosecutor, and I intend asking them lots of questions. Let me just deal with the South African Police Service. During the lockdown, a child of 14 years old was arrested. He was in the company of his grandfather, arrested at Rooiberg, put in the back of a police van. This happened a mere block from the police station in Rooiberg. The grandfather was in a police van, arrested. So the grandfather walked to the police station to wait for his grandchild, just to learn that the police are on their way to Nolstrom with a child in the back of the police van. And a lot of complaint. We act on behalf of the father of the child. So then the provincial commissioner in the Limpopo province wrote us this letter. He said, the above-mentioned case was dealt with and registered as a complaint against the SAPS. The case was investigated according to our national instructions, and proper feedback was given by Mr. Paja, Captain Paja, to the complainant, Mr. Leroux, which is not true. That complainant, Mr. Leroux, is the grandfather. We're not acting on behalf of the grandfather, we're acting on behalf of the father. We've not received any feedback. The complainant indicated that he was satisfied with the feedback given to him. He also indicated that he will inform his son-in-law and grandson of the outcome. We're acting for the son-in-law. We make it clear. We don't act for the grandfather. But then, he said, the complainant never indicated that he's represented or that your office has power of attorney to represent him. Talking about the grandfather. So any which way not to deal with a service complaint, they would do. So they carry on, and we then start writing. We're saying that this is wrong. We report him to the National Commissioner, because he's a provincial commissioner. We report him to the National Commissioner and we say, we write this letter keeping in mind the public pronouncements by the President and the Minister of Police, more so in August each year, pledging law enforcement's commitment to highlight and focus on crimes against women and children. Unsurprisingly, the promised narrative is not followed through by those officials who are duty-bound to endorse the practical implementation thereof. That we all know. I mean, every August we carry on. We say, whilst our attempts to have SAP's provincial management deal with the issues coming to naught, it has, on the other hand, proved to be one of the most preposterous examples of police ineptness and malfeasance we have encountered in recent times. Unique to this particular complaint is the creation of a superficial buffer in what we submit is the hope by the provincial commissioner that the complaint will disappear. So, really, the NPA, the police alike, they would just write you a letter, hope you'll go away. Because in most instances, people just can't take it anymore and they go away. So we just structure differently. These are attempts to keep the justice system afloat. We say, our office has sincerely hoped that after disclosing the endeavours on our part to highlight as early as possible to the local SAPS management serious concerns regarding lack of commitment by SAPS to investigate and secure all available and relevant evidence regarding the arrest, incarceration, and we say abduction. Just think for yourself, your child is in a police van, you don't know where. You go to the police station, you don't know where your child is. Child is 14 years old, with all the strict procedures that have to be followed if a child is arrested. We say, and abduction of a child, management would have taken steps to ensure our concerns are addressed and that we are provided meaningful feedback. Currently, the only tenable inference is that the conduct of these members involved is condoned. So I'm not going to go through it any further. I hope it gives you an indication of the steps we have to go through. What do we do? How do we try and assist? We use the skill sets in our office to force the SAPS and the NPA in doing their duty. To this end, we've had amazing success. You know, we've had countless matters where we got involved and they decided to prosecute. Now, for us, it's a victory, but we accept that for every prosecution we enforce, hundreds of victims have given up. And you know what's important? Those suspects still walk free to continue their criminal careers. Let me just share with you, we've had 5 matters of horrific child abuse in Brits. The NPA decided not to prosecute. We then got involved, we assisted the people that are now looking after the children, and what the NPA did, they just wrote us a letter saying, the matter's been re-enrolled. And we also heard now in the High Court. But just think what this means. It means a prosecutor a year ago decided not to prosecute. We became involved, and that prosecution is now so important that it will be heard in the High Court. Now, without us, the mothers that came to see us, they were at their wits' end. I mean, what do you do? How do you get the justice system to function? How do you get these matters in court if you don't have access to the people with the necessary skill set to make it happen? So, and that's why I'm saying, if they withdraw those cases against these people, do you know who's walking the streets with us? People that would do that to children. Obviously, the people that don't address with their political careers because of continue with their political careers, and they now have access to tax money, huge municipal bills, and so forth. So that's the first thing we do. So the first thing we try and do is we use our skill set in the office to force the SAPS and NPA in doing their duty. We have created a unique and exciting capability to privately prosecute. You know, if you just think about this, the ability to privately prosecute has been in legislation and available since 1828. Since 2017, everybody's talking about private prosecutions. I mean, I've seen academic papers on private prosecution, which never happened before 2017. Now it's become a household process, private prosecutions. But before we started private prosecutions, nobody spoke about this. It was unavailable. So and I must say that the Office for Private Prosecution, I mean, it's a brainchild of Mr. Kriel, and it's the endeavors of AfriForum to create something like that, which is absolutely brilliant. I'm proud of it, and I'm sure that everybody in our organization should also be proud of it. So it's a specialized field of developing an alternative capacity and ability to prosecute matters. We are looking at the possibility of creating a private prosecution, if you want to call it authority, but the private prosecution capacity that will be available to people that would just want to elect their own prosecutors to prosecute the matters. So you can have a prosecution prosecuted by a prosecutor of your choice. Will it happen overnight? Definitely not. Won't happen overnight. Will well-known and vocal academics tell you it's impossible and that Nel is delusional? Yes, they will. They will tell you Nel is delusional, will not happen. But did anybody before 2017 anticipate or predict a private prosecution office? No, not them. Nobody did. Now we have that. And I've heard this from Mr. Booysen, so with apologies to Mr. Booysen, everybody in this room older than 50 years old were born in a state hospital. I mean, there were no private hospitals. You agree with me? So there were absolutely no private hospitals. If you 30 years and younger, you were definitely not born in a state hospital. You were all born in private hospitals. So when we were born, I mean, that's a long time ago, no? You can't even think that far back. But nobody thought that the Moedersbond will not be the only hospital in Pretoria where people will be born, because everything functioned. I mean, when I grew up, when I was at school, I know of 2 or 3 private schools, and I always thought it's where all the naughty children go, to all these private schools. So what I'm trying to say is, nobody thought way back that there will be private hospitals, private schools, and so as people sit here and think private prosecutions as an option will not happen. It's against the Constitution, it's against everything. But what I've shared with you today is the collapse of the criminal justice system. If there's no criminal justice system, we have to put something alternative in place. And that is what I think we can do. For now, what we have available now, we will not allow people to be sheltered from prosecution because of the political and other connections. Right? We're building up the capacity. But we cannot allow a sinking criminal justice system to affect our day-to-day living. So more and more, we deal with the collapsing criminal justice system. You know, I wanted to discuss with you the politicization and incompetence of the people that have to preside over cases. So, I mean, you followed the JSC proceedings. You've seen the questions that ask people that we want to preside over the most serious cases that we can ever have. We have practical experience. We have practical experience of judgments in the Mbatu court that when you read it, you think, but, and it's just my perception, judge might be right. Don't want to, I'm very, very scared of contempt of court. But when I read it, I think, but this can't be. And then we prosecuted in the Booysen matter. And in the Booysen matter, the court allowed a Section 174 discharge. So just after the state case, the accused was acquitted. We then filed an appeal. If you file an appeal, the magistrate must present his case. So he must indicate to the appeal court the reasons why he did it. We received that. Just go to the next page. See that page and the next page? That page. That is the reasons we received from the magistrate. There's not a single word about Section 174 and the principles in terms, I'm not lying. There's not a single word about Section 174 and the principles that we addressed in our application for leave to appeal. So there's lots more to say, but I think I've said enough. And I said even more because I knew that Mr. Booysen would not be here. So I hope there are lots of questions, and we'll deal with all the questions later. Thank you very much.
Thank you very much, Advocate Nel. I would caution those academics not to proclaim their statements too loudly, because innovation and breaking new boundaries is something that AfriForum and the Private Prosecutions Unit has become very good at doing. So I would very much caution them to keep their opinions to themselves. As Advocate Nel mentioned, two of our speakers, General Johan Booysen and Kennedy Johan, could unfortunately not make it today due to unforeseen circumstances, which is a pity because they would have really added some extra value to this conversation. Kennedy, just for interest's sake, he's got an amazing story. He had to flee Rwanda, and he walked 6,000 kilometers from Rwanda to get to South Africa, and where he, through trials and tribulation, eventually managed to qualify as a lawyer, and is now a practicing human rights lawyer. But we'll definitely bear them in mind for future events. I would now like to welcome Dr. Lancel Lewis to please present to you.
Good morning, everyone. Maybe we should just stand up for 1 minute and take a comfort break. Not everybody is a wrestler, can keep on going forever and a day. So just stand up and stretch your legs, and we'll start off in a minute's time. Whilst we are at it, you will be mindful that in my presentation I have prepared a couple of hard copies to be handed out and distributed amongst those that is in the audience, in an effort to assist you with following my arguments. For those of you that will be interested, there will be a link made available by Natasha Venter afterwards to provide you with the final copy and whatever I had to say with regard to this matter. Okay, if you are satisfied, we can start. Well, this morning I feel like a hooker, and not the type that hopefully many of you are not familiar with. I've been linked between two props, number one, Gerrie, and on number two, Koos, number three, Koos, the other prop. We all know rugby, so I'm in the middle, typically number two, the hooker. Be that as it may, so that's my fortunate situation this morning. That was the one issue that came to mind, but there was a couple of things that my colleague mentioned, which I obviously, just in the passing by, have to revert to. I listened to Gerrie, and from what I've gathered in the couple of examples that he used, that I thought I was busy listening and attending to a Jerry Springer show, because that is exactly what it is. It's unheard of. And fortunately, I don't know whether he remembers, but many moons ago, I myself was on the prosecutorial side of things, and I also had the benefit of prosecuting with under the auspices of people like Klaus von Lüders and even Jan de Oliveira and some of the other decent attorney generals in those days. Senior advocates that knew their way around and that had a huge success rate as far as prosecutions are concerned. So I was on both sides of the law and what have you. Therefore, I can also speak from that experience. Okay, you referred to the JSC, and in my paper and deliberations, I will refer to the JSC as well, Judicial Services Commission, and I will not entertain any questions asking me what the peril evidence rule is all about, because that's the type of questions they can't answer. And then there was also reference to private prosecutions, and maybe we should have a discussion on that as well. I am all in favor of your suggestion to have an institution ultimately where we can have access to, without the intervention or necessity of a Italian prosecution certificate in terms of Section 7 to 17 of the Criminal Procedure Act, for example. I mean, that will expedite these type of prosecutions. And whilst I was sitting there, I made a note for myself. I have actually observed that one of my master students, or hopefully that can develop in a doctorate at one day, is also in the audience. And he is currently busy with his dissertation on this very issue of private prosecution. So hopefully, listening to your argument and reference to a possible institution of that nature in future, there's something to ponder on in your dissertation. So I will be looking forward to that chapter as well. That being said, the title of my, well, just on that issue. So for that reason, I do not necessarily disagree, or agree with you rather, when you stated and made the observation that academics will not support you in that contention. We'll have a discussion on that later on between 12 and 1. The topic of my discussion this morning is, and listen to this topic, the ghastly prison overcrowding presents a huge problem. We know that. Yet another example of justice turning sour and judicial inefficiency and idleness. I ask the question, what happens to the rule of law? Now, so I'm going to combine a bit of academics, a bit of history, and then obviously some experiences that we've encountered lately. To get on the bandwagon of what Gerrie mentioned earlier on, those of you that have read newspapers the last week or so would have encountered that the public's confidence, especially in SAPS, the SAPS, deteriorated from 56%, which is not good at all, to currently around about 23 or 24%. That is the reality of the situation. And with all due respect to them, there are very merits in those criticism against them. Now, legal minds have stated that the overcrowding in our prisons can be directly traced to the so-called minimum sentence legislation. Now, those of you that's not familiar with the minimum sentence legislation, Section 51 of Act 105 of 1997 decided that there should be minimum sentences to be imposed on certain criminals convicted of usually the most serious of offenses, and, for example, in certain circumstances, people committing murder where there are evidence of premeditation, etc., must be sent for life imprisonment, first offenders between 15 and 20 years, etc., etc. So there are all these stipulations by legislation. The decision at that stage was that this act should only last for 2 years, and then on a yearly or annual basis maybe be renewed. What happened ultimately is that we are still stuck with that legislation. So the decision was taken, despite impassioned pleas in those days, within the justice system and from all other spheres of society, that it ultimately should be abolished. We're still sitting with it. So the question that immediately comes to mind is, why are we still sitting with minimum legislation? And should we have it after all these years? That surely was not the initial intention, at least, of the legislator. Now, crime in this country is reaching alarming, perhaps even epidemic proportions. Now, in case law, I remember the decision by Judge Kriegler in Dlamini, Dladla, Joubert, and Schieterkat. They all combined those applications and matters. He made the following statement, and I would like to quote from his judgment. He said, quote, "It would be irresponsible to ignore the harsh reality of the society in which the Constitution is to operate. Crime is a serious national concern," unquote. Now that still remains the position. These words were uttered in 1999. Can you imagine him sitting here today and listening to what we've listened to up to now? To what extent he would have made these observations as in a court case these days? Okay, as a result, the imposition of summary imprisonment has become almost automatic in all serious cases, especially when we deal with crimes of violent and so-called white-collar crimes where large sums of money are involved. These days, it's not uncommon, to listen to judgment where a judge will typically hand down very, very, very lengthy period of direct imprisonments. It's rather the principle than the exception to the rule. The view that seems to be that, at least in the public sphere, that the harsher the punishment, the more effective the protection of the public. But let me be frank. Crime is a very complex issue. It cannot be dealt with adequately in the space of a few brief paragraphs that I have tried to do, neither in the auspices of a day seminar like we have encountered today. Be that as it may, you'll see in my paper I have elaborated on the difference between the so-called crime control model vis-à-vis the due process module. Those are academic debates. But the principle ultimately boils down to the fact that our Constitution seems to rather favor the so-called due process module and not the crime control module. That being said, there are a couple of exceptions, obviously. One of them would be Section 6011 of our Criminal Procedure Act, dealing with bail applications, where there's sort of a reverse onus in certain circumstances on an accused to be allowed out on bail. Now, if you thought it's difficult to get hand of information from the various stakeholders, try to find out the exact numbers of inmates and related issues that I have tried to also refer to in my paper regarding to the overcrowding of our prisons, etc., from the Department of Justice and Constitutional Development. You won't get a response. So at best, you have to do your own research, and I have attempted the best I could to get the latest figures, and I had to compare it in some instances even to reports of Judge Fagan and others dating back to the early 2000s. It requires little imagination to picture the resulting pressure on sanitary and washing areas, sleeping, living spaces, visiting areas, consultation rooms, and the chance of participating in what the department referred to as rehabilitative activities if you have overcrowding of prisons in excess of 40% of their capacity. It cannot happen. That is the bottom line. It is a further small step from visualizing that the resulting increase in corruption of prison officials and criminal activities among these prisoners are run-of-the-mill every day, exactly because of, inter alia, this overcrowding of our prison system. Now, punishment was, in the old days, frequently what was known as flogging, which we know is unconstitutional these days. We cannot use a cane anymore. Fines, the pillory. Those of you that's not familiar with the pillory, that wooden bench where you would typically have your head stuck between it and your arms somewhere alongside that, and you would be publicly ridiculed by everybody that walked past. And then, especially in the United Kingdom, they very often rather prefer to deport people. That's where Australia, inter alia, came about. And then, obviously, execution. A growing humane approach to the punishment model of criminals led, obviously, to an increase in the use of terms of imprisonment. In those days, they did not put people in jail. They rather did these other stuff with them because it cost taxpayers money, and that's the last thing that the public want. These days, since we do not engage in that kind of punishments anymore, we have to resort to imprisonment. And because we are stuck with serious crime, long terms of imprisonment is obviously handed down by our courts on a daily basis. John Howard, now, he had influence, and he wrote a book in both England and United States that is even today unraveled in these states. He wrote on the state of prisons, a book that appeared in 1777, where he stated the following, that prisoners of all types mixed in the same jail, they are very prone to the spread of disease. And listening to our politicians lately, in many instances, that is one of the reasons they advance why they would rather let everyone out, go free, because we are so concerned with COVID and COVID-related issues that we forget about the reality of why they are there in the first instance. Most prisons were overcrowded, unsanitary, and degrading even in his days, referring to the days of John Howard. But, in my mind, sitting in the 21st century, nothing much has changed in this country. Our history over the last decade or two of abuse of power by the government, reckless disregard for respect of the law, and the criminal justice as such, culminated in a large proportion of our population being disadvantaged and poor. Inevitably, we are sitting on a time bomb. Since poverty and lack of skills are, according to research all over the international world, the major causes of crime. So nothing is going to change unless we sort that out. Rehabilitation, however, is especially difficult in a climate where it appears that the perpetrators of crime have more rights than the victims. More so, where the perpetrators are more than often the custodians of the Constitution itself, namely the members of our Parliament and other political leaders. Another reason why I decided to hand out my paper for those of you that's interested, I want you to understand me in context, because a lot of things that I would say today might not be find favor in the ears of some of our political leaders. Research showed that the length of the sentences does little to discourage criminal activity, while lengthy stays in prison often result in continued criminal activity. So, the threat of punitive sanctions probably deters a certain section of the population, usually those average citizens. those with relatively healthy social values. Not so for those with poor or impaired sense of judgment and control, and those with a low frustration tolerance. Also, custody presents no permanent protection for society, especially if prison inmates regularly receive some form of pardon or parole, often without just cause. And obviously, we will get to Zuma eventually as well. It is exactly for this reason why a prison is known and referred to in the world of criminals as the so-called University of Crime. What should happen is that government should all be fired, and a total cleanup must be effected this time around, with replacements at least of educated, ethical, and fit and proper individuals in accordance to international criteria, not the type of criteria we seem to encounter, for example, during interviews of the JSC. If the government is corrupt, for the gander in this country, the use of imaginative and more positive sentencing requires a large element of guts. I have actually alluded to one or two examples in my paper where I actually, this time around, actually referred to John Tlhophe, Judge President of the Cape Provincial Division, where at least in one instance, I was satisfied that he attempted, correctly applied his mind in handing down a judgment. But I'll get to the rest of, inter alia, his aspirations as Chief Justice later as well. Approximately 20,000 people a month are arrested unnecessarily. There are almost 3 times that number awaiting trial prisoners. Now, on average, thousands of people. In 2003, and like I said, it's difficult to get the latest information from the department, that number of people were released each month after being detained unnecessarily and spending an average of 4.5 months in jail. Many cases of arrest that should have never taken place are reported daily, and Gerrie also alluded to 1 or 2 examples. All too often, they are eventually withdrawn, maybe because of a lack of skills. We have listened to the arguments in this regard. In many instances, those charged could probably have been served with a mere notice to appear in court. Can you imagine the cost to society, to taxpayers' money on a daily basis, having an inmate in jail? At one stage, it was close to the 300 rand per day per inmate. Now, a decade or so ago, the estimated numbers of people leaving jail and carriers of HIV/AIDS amounted to about 43%. Rape is therefore a very real possibility for all held in our prisons, especially with the overcrowding of our prison system. I once again attempted or desired to see the latest figures in this regard, but apparently COVID-19 related figures are the only ones that we encounter and that is distributed these days. A United Nations report found that inmates of prisons in South Africa frequently emerged as worse criminals. An assessment based on substantially evidence from inmates themselves. Those that shows a propensity to commit crime and a person who is a menace to society should, in my mind, be kept behind bars. That is as simple as it gets. No one can dispute the need for strict justice, nor can anyone with a modicum of reason challenge the premises that society must show its disapproval of criminal behavior by imposing criminal sanctions. but not to an inflexible extreme. Criminal justice thinking has been distressingly preoccupied with the belief that treatment and punishment are polar opposites, and never the twain shall meet. Now, twain is a word from the Old English Shakespearean world, meaning the two will meet. On the contrary, they are inseparable and consonant to one another. There are alternative methods of sentencing for so-called non-dangerous and in particular first-time offenders that have been investigated over the years and even used in our Criminal Procedure Act, referring to Section 276. Options include, obviously, things like diversion out of the system and away from the influence of hardened criminals, correctional supervision, where you undergo certain courses, such as anger control, house arrest, community service, etc. At one stage, our minister had a brainwave, so to speak, to create a so-called peace army of conscripted first-time offenders to walk around in our streets to assist us in this regard. Okay, I'm not going to delve into that argument. Bottom line is, the system can never satisfy all stakeholders. As a group of society, used to be known as a prestigious group of society, lawyers, we all carry the full weight of a long and respected and honored tradition. If we fail to maintain an effective rule of law and a strong defense against corruption, we can hardly escape complicity ourselves. It bears constant repetition. Because we speak of judicial independence and then speak of the rule of law, we tend to make it sound as we have two separate concepts here, when they are so closely intertwined with one another that it's like a married couple being married for years, the one cannot live without the other. It will also be unwise to assume that judicial independence is inviolable. In other words, it's possible to get over the barrier. Corruption and the collapse of the legal system cannot be combated successfully without a strong commitment to the rule of law. That is a matter of prime significance for lawyers, especially in their professional organizations, but also it rests on other entities, including AfriForum, Judicial Services Commission, to name but a few. There is continuing research that has firmly established that a combination of a weak rule of law and perceived corruption is closely associated with stunned economic development. And that is exactly what we are currently experiencing in this country. But more positively, taking the international examples, there is definite sense that with a tradition of rule of law and with relative freedom from corruption, listen to the words, the confidence in the justice system can boom again and may even revive. And I'm using the word revive because currently it seems to be dead. Otherwise, no need for a revival. The relevant question for us to answer is obviously identifying at the margin where we can gain better leverage over the justice and prison system. I ask the question, are, for example, our schools and tertiary institutions of public policy and administration paying enough attention to the need for education and training in corruption prevention? Is that on the agenda or not? There are, after all, success stories. Historically, we can look at Singapore, Hong Kong, even in more recent years, Colombia, the Philippines, and some American localities. These days, elections frequently are fought on promises to deal with corruption. But ultimately, that winning an election is not tantamount to success in attacking elections. So, going into 1st of November, you will hear the repetition, we are going to go against corruption, over and over again. But the proof is in the pudding. It's not going to happen unless we do what I've suggested earlier on. Especially in South Africa, we've got a deep-seated cultural pattern, financial pressures, and corrupt electoral practices themselves that intercede. So it starts with the election process itself. Let us not get confused with some semantics and conceptual issues. If I refer to corruption, it is constantly defined as the result of some corrupt acts. In other words, principally, the bribing of public officials, something we are in South Africa all too familiar with. I submit that it's even more sweeping than this. In other words, it should be broadened and should include principles relating to immorality, dishonesty, lack of integrity, etc. Basically, describing everything and anything our leaders refuse to adhere to. In contrast to the rule of law, if applied correctly, imply a governing principle embodied in legislation or observed in practice in a consistent and transparent manner. And in this regard, I have referred in my paper to, amongst others, the example of the American Foreign and Corrupt Practices Act. That became law in that country more than a quarter of a century ago. It is one of the most comprehensive approaches against corruption. It extends way beyond criminalizing bribery to other corrupt actions and money laundering. Extensive record keeping is inscripted in that act. Not the type we encounter in South Africa, where almost the total justice system is hacked for weeks on end. How is it possible? Broad codes of conduct for civil servants and others are required in that legislation. Once again, I might make the side observation. Not the type we encounter in SA, where our possible next Chief Justice is short-listed candidate, currently found guilty of very serious allegations of misconduct by his own peers. Not I that say so, it's his own peers. Indeed, we require honorable and proper performance of public functions, fair and transparent government procurement systems, and not mere lip service by wannabe politicians. The threat is lingering in the first steps which must be watched. The first incursion by the executive into impropriety, the first compromise by the judiciary. We are all very familiar with the example of an employee who steals from his employer. The most difficult time is the first time the hand goes into the till. After that, each successive time is less difficult. So I ask the question again, how many times have we watched over the last decade members of our executive with their hands in the cookie jar? Eternal vigilance is not only a focus on the long term, but also on the immediate, today, and for that matter, every day. The insidious dangers are not less threatening than the obvious ones. And for judiciary to escort in the first small, even tiny steps may ultimately prove to be terminal. As civil society, we need to stand firm, complement our efforts with the now increasing number of other stakeholders who joined the fight against these outlaws, I call them. We must improve vigilance over the use of our own resources and protect ourselves against nationalization. The combination of a weak legal system and corruption is not only economically debilitating, but it's a death blow to the political health of both our so-called new mature democracy and maybe even our century-old justice system. In my opinion, the Zondo Commission merely touched the surface of illicit behavior in SA. And after many months and wasted taxpayers' money, the zeros almost too many to count on a balance sheet, the successful prosecution rate of those perpetrators is not even worth mentioning. Our legal system does not even seem to try to eradicate this evil. At least this is the perceived perception of the public. I do not blame such sentiments. A sporadic and more aggressive approach is urgently required to relieve the sense of frustration and alarm I mentioned earlier on. A reliable justice system and a strong society are two sides of the same coin. I ask the question, is this a mere impossible dream? As citizens, we are exposed to a frank recognition of a deep-seated resistance to effective action by government against the cancer on development known as corruption. The legal system can no longer dodge this issue. Our legal system is no longer the exemplars of the rule of law we once aspired to be and what we attempted to teach our young legal minds at our universities. Certainly, we are the rugby world champions, including world champions, if you ask me, in the extent of introducing numerous ill-considered legislation and regulations governing bribery, conflicts of interest, procurement procedures, campaign financing, protection of human rights, etc. Look at the COVID-19 regulations as examples and what the courts had to say about those. However, it seems to be, in essence, nothing but empty promises and a chasing of our own shadows. Obviously, all these measures, many of them applicable in our country as well, are ingredients of the rule of law. But sadly, the perception remains that the legal system has failed us, and crime in general is dominating our society. It's on the increase and it's widespread. Does it not breed behavior that more is accomplished by any reasonable measure of taking law into your own hands? The so-called jungle justice approach. We've seen that in our townships. We have recently experienced the continuing crisis in Zimbabwe and Swaziland relating to the issue of judicial independence. A similar crisis, and this is a bit of history, pertained, of course, in the old South African Republic, known in those days as the Transvaal Republic, in 1897 and 1898. The crisis then, in those days, referred to as the so-called Judicial Crisis. Sounds familiar, doesn't it? Makes for fascinating historical reading. This was the era when State President Paul Kruger was convinced that the courts had no testing right over legislation, and where he constantly promoted Law 4 of 1890, which replaced the legal force of a so-called besluiten of the Raad, in other words, the council, as published in those days known as the Staatskoerant, the government gazette, if you'd like, beyond any dispute. And then there were judges. Chief Justice Kotze, in the matter of Hess versus the State, reported in 1897. With him, other judges, at least 4 others, one of which was Judge Amershoff. They did not tolerate such disregard for fundamental constitutional infringements. The drama surrounding Law 1 of 1897 then followed when 5 members of the High Court, in those days, those were almost all the judges in the country, they assembled and they resolved that this legislation, I quote from the court case, violated the independence of the High Court. And if it was not to be resolved immediately, the court would merely adjourn sine die. In other words, for an indefinite period of time. There will be no justice in our courts. In other words, the justice system almost came to a complete halt. In my view, we have experienced similar trends lately regarding the possible abuse of power and arrogated powers by certain individuals resulting from the implementation of regulations in accordance to the Disaster Management Act. Unfortunately, I am not necessarily convinced that this time around our judges and our legal system is brave enough to tackle these issues with the same steadfastness, forcefully, and admirably as our ancestors did. This type of spurious principles of law involved that we experience daily by the legislator is not merely bad, but decidedly dangerous, as it deprives the legal system of its independence, being the principal bulwark of the rights and liberties of the people of this country. It is therefore our civil duty to avert a similar crisis by constantly and readily expose all forms of abuses of power whenever and wherever necessary. Public conscience should revolt against legislation and corrupt politicians. We should greet it with derision and the most intense of public hostility. Those responsible should pay dearly at the next election. An independent press and media are co-guardians of the rule of law. It is not supposed to be a popular contest. To protract with a response creates an illusion that we as citizens blindly abide with such arbitrary, untenable, and often blatantly illegal decisions of politicians. If we listen to any of these blandishments without reporting it, in my view, we have then failed our responsibilities. As lawyers, it must be construed to be derogatory to the honor and the dignity of the profession if any of its members takes what is known as a laissez-faire approach. You'll remember the words of Chief Justice Marshall in the US Supreme Court Marbury versus Madison, where he dramatically introduced the testing right of the federal court into the US. In that jurisprudence, he emphasized that the Constitution of the USA, as the expression of the popular will of the people, was supreme over any ordinary law and laws in defiance of it. It should be regarded as unscrupulous political innuendo. This is to this day, arguably, the most famous case that ever have been decided by the US Supreme Court, and currently even still considered as the linchpin of the US constitutional law. Prisoners might be an unpopular part of our community, but that does not allow the authorities to treat their concerns lackadaisically. The democratic nature of any government will always be tested on the manner in which it treats its most weakest citizens. That is why we get upset when so-called medical parole is abused for political favors of certain elite and not in accordance with the principles set out in, amongst others, Section 79 of the Correctional Services Act of 1998. In my paper, I refer to the case law of Stanford. In my opinion, things appear to have fallen apart in our criminal courtrooms. Criminal trials have become a farce. It has very little to do with arriving at the truth and dispensing justice, but more to play a game of chess politics. It obviously brings the entire legal system into disrepute. Debate is polarized, and that results in distorts of the truth, the obfuscation rather than clarification of facts, and ultimately an injustice. Our system seems to assign to counsel a different mission, in many instances to seek legal loopholes and to couch it in the language of legal jargon, instead of applying the trite principles of the law. As a result, amongst other things, our dire need for transformation of the legal fraternity. Too often, the judicial officer's subjectivity or personal bias, which informs his decision, is what Oliver Wendell Holmes put forward as the so-called, I quote, inarticulate major premise, unquote. And now I'm going to step on further toes. Last week, I personally experienced this matter, and this in a matter where a teacher was charged and convicted of assault on a minor learner, and the famous race card was played, while race was never, ever an issue in evidence whatsoever. There is a bias inherent in any judicial officer's colored value judgment that is a product of his or her background. That is trite. We cannot dispute that. This revelation is so obvious when listening to the interviews conducted by the JSC for the appointment of judges. And for those of you that doesn't believe me, look at all the various research that I have quoted and alluded to in my argument as well. In October 14, 2008, Judge Lancel Lewis made a statement. She referred to, in Johannesburg during a South African Institute of Race Relations briefing, she referred to the troubled state of the South African judiciary. Now, that was done a decade ago. Have anything changed? Put bluntly, the standard of the bench, on average, there are exceptions to the rule, has declined. The problem lies in the candidates being appointed, or, for that matter, overlooked for appointment. Merit, skills, and experience are still taking the backseat to a political fealty 27 years after 1994. To add insult, counsels very often substandard, less than stellar court performance and pleadings ultimately comes home to roost. I suspect that my next observation might be construed as too simplistic. This lack of quality, in my mind, whether it's on the defense side or on the prosecutorial side, can directly be attributed in a combination of factors, such as, and maybe I'm too simplistic, the requirements for university admission, the content and quality of our LLB degree, the professional requirements for eligibility to practice as a legal practitioner, regardless attorney or advocate, and perhaps even more. Let me conclude. Things fall apart in the criminal courtroom. The legal system is fallible and does not guarantee that the truth will be established and thus that justice will be done. It at best simply establishes facts that the court subjectively considers having met a certain evidentiary threshold, whether true or not. It is time for the JSC to recognize that sacrificing the quality of the judiciary on the altar of political ideal, already largely achieved, if you ask me, is too high a price to pay and to expect citizens to continue to pay their taxes for. It would not be amiss to recall the well-known words of Oscar Wilde before sentencing an offender to imprisonment, and I quote, "The vilest deeds, like poison weeds, bloom well in prison air. It is only what is good in man that wastes and withers there. Pale anguish keeps the heavy gate, and the warder in despair," unquote. Thank you.
Thank you very much, Dr. Curlewis. Before I welcome our final speaker, I just want to, I see we are running a bit behind schedule. We're going to have our final presentation, and then we're going to have a quick panel discussion, after which we'll open the floor for some questions, and then lunch will be served. Please welcome Professor Koos Malan.
Good afternoon, ladies and gentlemen. Let me just make sure if it's afternoon or morning. I don't want to make such a basic mistake. It's afternoon. Good afternoon, ladies and gentlemen. Ladies and gentlemen, it is a great honor to share this podium with my two esteemed colleagues. The one, Gerrie Nel, or as I know him from decades back, Gerard Nel, who at this stage should actually have been the Attorney General of Transvaal. But fortunately, he is not. Fortunately, he was actually finally commandeered by AfriForum in order to perform the very heavy responsibilities he is performing at the moment. And if there was ever a need for checks and balances of the kind which are exercised by your office, it is now, and I think you're doing well in that regard. It was, in fact, very informative, ladies and gentlemen, for me to listen to the extreme amount of detail of the activities of the office. The office is indeed extremely busy. Ladies and gentlemen, back when this office was opened by AfriForum and Advocate Nel was appointed, there was a colleague of mine, I have forgotten his name, but I think he's a professor of constitutional law at the University of Cape Town, who said that this is really inordinate for an institution like this to be formed. Now, he was obviously wrong, because if there was ever a need for an institution of this kind, well, then it is now. And the need is becoming more profound actually every day. Ladies and gentlemen, the information that was shared by us by Advocate Nel is in fact extremely revealing, demonstrating the extent to which the criminal justice system has already fallen apart. I'm telling you, I know him for a very long time, and I could never have expected that I would heard him speaking these words, because I know he was an extremely loyal state prosecutor and extremely loyal state advocate, as we called them in those days. So, if his testimony is that the criminal justice system has in fact collapsed, to quote him verbatim, he is to be believed. Ladies and gentlemen, I'm also honored to share this podium with my esteemed colleague, Dr. Llewelyn Curlewis. I'm not going to expand anymore, but saying that he is really a tough, headstrong colleague, and I'm very glad about that. Ladies and gentlemen, I'm going to present something to you which, to a large extent, fortunately, it's not that overlapping with what has already been said. There will obviously be some overlap, but actually not that much. And in order to present to you what I set out to present, I'll mostly read today instead of actually speaking, which is actually a novelty for me, but that is at least in order to stay within the constraints of time. And hopefully, ladies and gentlemen, when especially I come to the end of this presentation, we will also touch on what one might regard as solutions to the current problems that we are facing with the collapse of the criminal justice system. Solutions which might be outrageous at first glance, but on proper analysis would actually, I think, prove to be staff and dangerously lightweight at the bottom. That is in relation to officers that have to execute the actual police work. Moreover, as all of us know, the police grapple with high levels of corruption within their own ranks, also among the highest echelons within the police. They are ill-equipped, lacking a sense of maintenance, and seriously devoid of the essential prerequisite of police work, such as crime intelligence, which we have seen especially during the uprising in KZN and certain parts of Gauteng during July this year. Moreover, its administration is in a very bad state. There's a lot of evidence pointing to that. Let me immediately add, ladies and gentlemen, that there are good people in the police. Sometimes I meet them, you too. I salute those that are dedicated within the police, but at the same time, I really feel sorry for them to be operating within a system that they have to operate in. Occasionally, the police are effective, yet a striking feature is the lack of assertiveness, self-confidence, and self-esteem. I think this is important, because whenever you think of a policeman, ladies and gentlemen, the police have over the years failed to deal with large-scale crime in various fields, such as, I mentioned only a few, but that's actually very important, such as the construction mafia within the construction industry, the road truck mafia in the transport industry, the mining mafia, often referred to as the so-called Zama-Zamas, and the like. And recently in the KZN South Gauteng insurrection. And we can add to that a lot of additional examples, ladies and gentlemen, such as the inability or reluctance to prosecute crime whenever politicians, be they in the African National Congress or the EFF, are involved. In the case of the construction mafia, which, by the way, is a protracted problem, having come over ages, many, many years. In the case of the construction mafia, the police failed consistently to intervene in large-scale disruption of construction projects. There are no prosecutions. In the face of the fading state, and that is the crux of my presentation, in the face of the fading state, the building industry had to fend for itself or simply vacated the premises where they were supposed to do their work. I personally had made some telephone calls, speak with people, senior people within the construction industry, and that is actually their verbatim evidence. The police were simply absent, and the building construction had to fend for themselves. Then the road traffic mafia has been with us for many years, leading to the destruction of, only in 1 year, 1,300 plus trucks, more than 200 deaths and damage amounting to billions of rand, and also the large industrial hubs such as Gauteng, Western Cape and Durban being cut off from each other as a result of the main arteries being disrupted. We've seen that. For those periods during which they were disrupted and cut off, there was in fact no single national economy. There were 3 disrupted economies in those 3 areas. In the case of the construction mafia, the police have proven the police have proven never to be in control of such situations. The waves of violent criminals are just too overwhelming. That is the evidence of people, senior people within both these industries. The police were simply the waves of criminals are simply just too overwhelming for the police to deal with. Often the police were mere onlookers while the plundering continued undisturbed. A similar scenario has been going on for years in relation to the mining mafia. The responsibility for personal security, and all of us know that, the responsibility for personal security, safety in suburbs, business premises, etc., has quietly yet vastly been devolved from the absentee state to private security measures, either private security companies, neighborhood watches, farm watches, and several more. Today, South Africa has per capita the 4th largest private security industry in the world, finding itself in the company of the likes of dangerous banana republics such as Guatemala, Panama, and Honduras, as a result of the absence of the police. If there would have been any doubt surrounding the police's ability, the events from around about the 10th to the 20th of July this year have finally dismissed such doubt. In front of the eyes of millions of TV onlookers, the police have graphically proven their inabilities. Conversely, the communities had to act for themselves in KZN and certain parts of Gauteng. And communities, black, Indian, and white, and that was really something to see, not only whites. Many times, I think whites are inclined actually to think that it's only us, only white people who have to fend for themselves. That was in fact not the case. Communities, black, Indian, and white, did so with striking efficiency. When I say striking efficiency, no pun intended. Most probably because they have over the years, through communal and personal initiatives, grown into the habit of doing it on their own. Ladies and gentlemen, I can add a number of other fields where crime was committed, such as what I've already mentioned, namely criminality within, among political figures, such as the ANC and the EFF. Nothing has been done about that. We know that the EFF has been embarking upon actually a whole trend of blackmailing of any persons that they do not agree with. Yet, no action at all. It simply goes on with impunity. We were informed today by people well placed in with their excellent knowledge and vast experience on the dismal state of the prosecutorial authority. We know that unlike before, effective prosecutions have descended into the happy exception amongst the normality of failure. Gone are the days, and I'm to be corrected here, gone are the days where each magistrate's court was manned by a contingent of able prosecutors, assisted in close cooperation with an array of skillful detectives and police in uniform to process prosecutions at 5 per day per court. I don't think it happens at the moment, not at all. I briefly add, because I think we have to involve that too, I make a reference to the South African Defence Force. I briefly add that the Defence Force, though not in the front line of crime prosecution and combat, but certainly a last resort when push comes to shove, suffers from the same ailments as the police. That we've also witnessed on a variety of occasions. Now, the question that we have to ask, ladies and gentlemen, are things going to change for the better? And if I hear them correctly, if it has not been said in as many words, it has at least been suggested by my colleagues that unless there is really some very active intervention and very resourceful intervention, things are not going to change for the better. So the answer to the question, are things going to get better, is at this stage, no. The fiscus has been depleted. We know that. The fiscus has been depleted by a thievish oligarchy, which is the ANC government, masquerading, I know it's harsh words, but it's to be proven, one can prove it, masquerading as a government, and there is no money available to cure these ills. Moreover, the police, prosecutorial authority, and the army has lost its skills to such an extent that it cannot be remedied. The dreadful situation is there to stay and destined to get worse. Looking at the state for help is looking in the wrong direction. No help will be forthcoming from there. So then the next question, what does this mean from a constitutional point of view? That actually was my brief, ladies and gentlemen. Having listened to my colleagues and having also summarized what I have witnessed, the question from a constitutional point of view, where are we now? Is there anything to say about this dreadful situation indeed from a constitutional point of view? I think a lot. Let me explain. The guarantee for safety and security for which the police, the prosecutorial authority, and the army have to shoulder responsibility is the very raison d'etre of the state. It's the reason why the state exists in the first place. Taking up that responsibility to take care for safety and security and effectively fulfilling it is the very reason for the state's existence. The life of the state is measured by that. The more and better it succeeds in discharging that responsibility, the more it is in fact a genuine state. The less it does so, the more it retreats, thus becoming less and less an actual state. And I think that brings us to the core of the constitutional perspective to this issue. To the extent that the state effectively fulfills its responsibilities in this regard, it has a legitimate claim to obedience and to taxes. Once it reneges and fails to guarantee safety, and the more it reneges on this score, the more it forfeits its claim to obedience of the citizenry, and the more its taxes assume the characteristic of blackmail instead of qualifying as actual collection of state revenue. Now, I know this is perhaps something irresponsible to say for a constitutional jurist. So precisely for that reason, I add the following. This is not a call for a tax revolt, which I suspect, however, is already full-scale underway through a huge array of methods. It is, however, a realistic account of what taxes descend into when a government reneges on its basic responsibilities in the way in which the present South African oligarchy does. The bottom line, therefore, from a constitutional point of view, is that what we perceive to be the Constitution, the 1996 Constitution, has already fallen into disuse. In other words, it has lapsed with respect at least to the essential factor of state responsibility for safety and responsibility to shoulder safety and security. It has already lapsed. It has fallen away. So what should be the responsible response of the citizenry, you and me and all the other people out there, all the other citizens out there? What should be the responsible response of the citizenry to this state of affairs where the constitutional order has so lapsed? First, we should understand that this is a gravely dangerous situation indeed, because a scenario in which the state proves to be largely incapable of sustaining a functioning system of criminal justice is one in which unbridled chaos, violence, and war. He said, in such condition, in his old English of that time, in such condition, there is no place for industry, because the fruit thereof is uncertain, and consequently no culture of the earth, no navigation, the roads were blocked, no navigation, nor use of the commodities that may be imported by sea. This is what we saw, ladies and gentlemen, when the electronic system of the harbors were interrupted. No commodious building, very interesting, no commodious building, referring back in 1651 actually to what we're experiencing now in relation to the construction trade. No instruments of moving and removing such things that require much force. No knowledge of the face of the earth. No account of time, no arts, no letters, no society. And which is worst of all, continual fear. This is in fact the situation in which many people live in the absence of a proper criminal justice system. And danger of violent death and life, as Thomas Hobbes put it so dramatically, but very often, especially in current day South Africa, and life of a man is solitary, poor, nasty, brutish, and short. So this, ladies and gentlemen, is what we are facing in current day South Africa. Not if you are living in a community somewhere in Pretoria, amongst people of the same cultural convictions and so on, but in many other places it is. But, ladies and gentlemen, Hobbes is only right in part. Since the vanishing of the state, because this, constitutionally speaking, is precisely what we are facing. But Hobbes is only right in part, since the vanishing of the state does not necessarily spell this horrifying Hobbesian condition. Because when the law of the state falters, a new law, and I think we must increasingly attend to this, a new law, and let me introduce this term. It's not that a clever term, because we have the terms available. A new law, a default law, in Afrikaans verstekreg, could emerge in its lieu, in lieu of the state's law. Not the Hobbesian horror. Now, you referred to civil duty. Gerard, you also referred to civil duty. In order to avoid this terrible Hobbesian horror, it's our civil duty to actually see to it that this default law, hierdie verstekreg, is in fact put in place and is in fact administered. This is the law in which communities, based on communal consensus, and ladies and gentlemen, where you live, there is in fact communal consensus. People of the same culture, and I'm not only referring here to Afrikaner culture also, but by and large people of the same culture, create their own law and enforces it. At the root of this is controlled boundaries, combined with, and this is perhaps an extraordinary thing to say, combined with the suppression of unrestrained freedom of movement. If you want to be away from the possible encroachments of your rights, if you want not to be within striking distance, ladies and gentlemen, of your life and body be threatened, then at least there should be no freedom of movement for the criminals and potential criminals. It's not outrageous, it actually speaks for itself. So at the root of this, of verstekreg, of default law, is controlled boundaries combined with the suppression of unrestrained freedom of movement. Inhabitants, citizens, should be drawing borders and police them, thus establishing enclaves of safety, security, civilization, education, and industry. Moreover, that is nothing new. Black communities, both rural and urban, have done this for ages, without the others, more specifically the white population, being aware of this. Lately, in the past decades, this has become a general practice covering a broad spectrum of arrangements, from the rising number of security towns and suburbs, beamed suburbs, roamed by private security officers and neighboring watches, to Orania and the hundreds of other ethnically self-ruling towns throughout the country. This is reality, where you do in fact have proper crime control through prevention. In this way, structures and areas of default law on the ashes of the faltering state are already with us. They are not free from abuse and malfunctioning. We have to face that. It's possible that that can also, and it will also, generate its own problems. Yet, in these structures and areas, actually healthy communities exercise control over themselves, applying their own default law instead of being at the mercy of the blundering, failing, faltering state and of violent crime. This is the direction in which communities should be investing their resources and energies. This is the crucial constitutional consequence of the retreating criminal justice system and the faltering South African constitutional order. Thank you.
Thank you very much, Professor Malan. Gerrie, I'd like to start off with you, and then I would like the Professor and Dr. Curlewis to please add on to this. The Jacob Zuma parole fiasco. So everyone saw this coming. Everyone was saying he's going to use the Shabir playbook, he's going to get medical parole on this. Even though it was absolutely obvious, it still happened. I don't know if you guys have seen the news, but Zuma was spotted in a casino over the weekend. So once again proving to us that his death sentence is a fabrication. How did we get to a point that there's room within the parole system for it to be manipulated in such an obvious manner?
Okay, perhaps you won't like what I'm saying, but I'm all for parole. I think it should be applied, but it should be applied equally to every person. So, because if we say no parole for Jacob Zuma because of medical reasons, what are we saying about other people like Balus and all those kind of people that have been imprisoned for, what, 30 and more years? So for me, it's not about the principles of parole. It's about applying the principle equally to all people. So I really do think, and perhaps Llewelyn knows more about this than I do, that the imprisonment of someone must have as a purpose to have somebody rehabilitated and allow such a person to come back in society. Now, if parole is one of the ways of doing that, then certainly we should apply the principles, but apply them equally to all people. I'm all for parole, I'm all for medical parole, and I don't think it's so much the fact that it was granted. I think it was granted to politically connected people and not to other people in prison that I think deserve it.
Yeah, thank you. I think this is where I have to come in. It's very clear that in terms of the legislation we have available, and I'm on board with Gerrie as far as that is concerned. There's nothing wrong in principle with the requirements set out in the legislation and even the way it is supposed to be. Let me use the word supposed to be conducted. So parole is part of our law. It's strike law. Nothing wrong with that. There are instances where one would have expected it to be applied. Correctly pointed out, and I've used the words, what's good for the goose is good for the gander. It should be used on par with one another. You should know how it's going to apply to you. Koos should know how it's going to apply to him, and I should know how it's applied to me. So, equal before the law. That is a principle of the rule of law. It's an international recognized principle, and there's nothing wrong with it. Unfortunately, in this instance where what we have encountered, especially referring to former President Zuma, and let's not even go into the way the court cases play out, because that's a whole new debate and maybe can keep us busy for the rest of the day. But the fact of the matter is, he should not be in a position where he can stand on a podium or even on the internet and while he is still under sanction, And remember, his sanction have not prescribed. He's supposed to sit out a 15-month period. Forget about the parole that was awarded. Parole does not mean that you have now been expunged from your sanction. It means it's going to be conducted in another manner, this time around under house arrest, etc. So one would have expected at least the department to indicate what strict parole conditions have been handed down in his instance, especially because he is a person of interest, because it's a political field person, because we are on the brink of an election taking place. So one would have expected that one of the, if not the most obvious principle of parole, in this instance should be a condition that he is not allowed to speak to the members of the public, journalists, the media, anybody out there, pending the completion of his 15 months. That is, as far as I'm concerned, self-explanatory. Why it did not happen? Well, we should ask the person in charge with regard to that, because that is a principle, in actual fact, a condition that is adhered to and handed down basically on a daily basis for all people that receives parole, correctional supervision, even day parole. That is my answer to that question.
Prof. Malan, would you like to add something to that?
I think one could perhaps just add one thing, and that is that the chances of Mr. Zuma ever being prosecuted and serving a sentence after this event is really zero. There's no chances of that happening. If ever this criminal case at the moment pending at the Maritzburg High Court comes to fruition, and if ever there's a trial, and if ever that leads to him being convicted and punished, he won't serve punishment. That's gone. There's no possibility of that. And I think this parole has clearly demonstrated that. There's no rule of law, especially not as far as Zuma is concerned. He will never serve any term of imprisonment.
Okay, let's talk some solutions. Before we talk about the criminal justice system as a whole, Llewelyn, I'd like to ask you first of all. You mentioned some other options rather than sentences or minimum sentences. Now, I don't think we're in a position where anyone is advocating for people to get flogged again. Well, I don't know. Maybe someone in the audience might disagree with me. Maybe I would have disagreed if I wasn't on a public platform at the moment. But what other options are there?
Well, for a start, we have it available already. We know about things like diversion. We know about all these various programs that you typically find under correctional supervision. And even our highest courts have on occasion handed down correctional supervision, whether it's in terms of section 2761H or 2761I on numerous occasions, for even the most serious of convictions and offenses. But it goes down, and ultimately, the question that must be asked is, how can it effectively be regulated? Monitoring is the answer here. If we do it according to the book, then there's nothing wrong with it. I would love to see our system where our inmates, or soon-to-be released inmates, assist in community service, where they are responsible to do the work and plow something back into the community, to sweep our streets, to assist where the taxpayer actually funds them. But at this stage, we have inmates, overcrowding of the prisons. We have to pay for them to sit there, to be released sooner than later, and nothing comes back to the community that have supported them and paid for them to be there, to pay for the justice system. Can you imagine the high price tag to get one successful conviction in this country these days? Especially if they use all these delaying tactics that we have seen. And I want to make a comment on that later on as well. Koos referred to the Zuma trial in Pietermaritzburg going nowhere. But can you imagine, we need to do, in principle, we need to fulfill our duties and to prosecute, because a president will be set if we do not do it. But whether he's going to spend one day in jail ultimately, even on the assumption that he's convicted in how many months from now, that remains to be seen. What about the amount of money that we've spent on the Zondo Commission of Inquiry? We are talking about millions and millions. where are we going with the prosecution in that instance? I cannot see there will be a report. We'll know what the outcome of the report will be. I mean, that is not, doesn't take a rocket scientist to answer that question. There was corruption, there was all these other things going on toward on the highest level, but are we going to prosecute them? And here's the crisp of the question, and Gerrie must answer this one for us. Sorry to pass the bucket, Gerrie, but Section 18 of our Criminal Procedure Act makes provision for prescription of criminal trials. And we are talking about a 20-year prescription period here, especially in certain instances of crime, white-collar crime, to a large extent fall into one of those categories. If we take 10 years to fight a case, a battle in court to get a conviction, and it takes another 10 years prior to that to start the process of prosecution, to do the investigation, then we are already there. How is this going to play out? So we have a problem, and these delay tactics might be one of the political chess games that they are busy playing in order to get to that stage where this is going nowhere, regardless of what the outcome of the Zondo Commission's report would be.
May I just come in here? You know, we all talk about Zuma. It's keeping us all busy. We all get the feeling that the justice system is functioning because, look, they want to prosecute Zuma. Look, Zuma was convicted for contempt of court. So that is what we're doing. The justice system is working. But it's working on a 10-year-old and a 20-year-old matter. It's working in 10-year cycles. You know, in this 10-year, the friends of this president or people that are linked to this faction in the ruling party will not be prosecuted. They'll only be prosecuted in the next cycle of 10 years. They will be prosecuted. So really, as far as the prosecutions of Mr. Zuma is concerned, I think that Billy Dana is doing an absolute good task of it. He's doing very well. But we should not be hoodwinked by the Zuma prosecutions. We should ask, what about the prosecutions that happened now? What about all the corruption that happened now in the lockdown period with all the corruption that happened now? So we are all hoodwinked by the media and whoever's involved in Zuma, you know, talking us about Zuma. This is what we're doing. So as far as your question is concerned, you know, that is always a problem, because we only get to investigate matters after a 10-year cycle, you know, in the cycle of a new factional portion of the ruling party. So the only answer there is that's why the media, us, and all those kind of people must make sure that their prosecutions, just to halt the prescription. You know, you just have to do something to halt the prescription. And if you allow the prescription just to carry on, well, that's the end of it. But you know, Jock, we keep ourselves busy in lots of these discussions about the Zuma conviction in the Constitutional Court. You know, if I just use that, I get goosebumps. To use the word Constitutional Court and conviction in the same sentence, to me, is just wrong. It's just absolutely wrong. But let us look at what happened now, because, you know, the amount of corruption that happened in a year, 540 days, linked to what happened, what's involved in the charge sheet of the Zuma prosecution, is amazing. So that's just what my input.
I just want to follow up on that issue. You asked me other possible solutions. There's obviously another possible solution that comes to mind. And make no mistake, it's not the first prize, and it's not ideal, but it is an answer to the question, and maybe this is the short-term answer, that we should expedite maybe prosecutions and get to more agreements in terms of Section 105 capital A of our Criminal Procedure Act. Now, that is the so-called plea and sentencing agreements. 99% of all criminal matters currently in the United States get finalized on that basis. So it's a bit of a give-and-take situation. Instead of charging people with 1,000 counts of corruption, rather let them plead guilty on 100, get a conviction, get a criminal conviction, and see to it that those perpetrators end up in jail for a lengthy period of time. What is the difference sitting out in jail for 100 years in comparison to 2,000 years? I mean, the bottom line is they must get there, because that will immediately show to the public that we are doing something immediately, expeditiously, to try and facilitate the problem. And I know these days there is a trend, maybe in the bigger cities especially, where we see some of these plea and sentencing agreements getting entertained. But as far as I'm concerned, it's something that's there that is not used to the extent that it should be used.
I just want to mention something about the Zondo Commission. It has now been mentioned by all three of us. I also think that there are not really going to be any prosecutions following from the Commission's work, simply by reason of the fact that the prosecutorial authority and the police do not have the people, the know-how, to actually process prosecutions. However, even though it is true that the Zondo Commission has cost a tremendous amount of money, I think eventually it is proving to be a worthwhile exercise. I'll tell you why. Because it has cast light on the actual nature, the character of the South African state under the ANC. I've used in my presentation the word oligarchy on 2 or 3 occasions. Namely, it's not a democracy, it is a small elite who make use of a variety of criminal techniques, corruption, fraud, theft, and so on and so forth, in order to enrich themselves, and in order in that way to see to it that at the next election they once again convince, bribe, in inverted commas, and so on and so forth, the electorate to vote for them and to get them in power again. That's not a democracy. It's a farcical democracy. It's an oligarchy. So, and I think what the Zondo Commission has done is to actually cast light on the fact that this is in fact the position. We are much less starry-eyed as to the actual nature of the South African state than before. The evidence has been just too overwhelming, day after day, for us to actually dodge that. Nowadays, the term that is very often used to describe many states, including quite a number of sub-Saharan states, is the term a criminal state. Now, that's not a legal term. It's a term of political science. But in a considerable sense, the South African state has in fact descended into a criminal state, even judged by the level of criminality that senior politicians, especially the government, the ANC and so on, are involved in. It's a criminal state. That is what the Zondo Commission has demonstrated.
Would you like to add on to that?
Yeah, I'm going to do a very dangerous thing, and it's not to not agree with Professor Koos. That's a very dangerous thing. But I'm more critical about the Zondo Commission. I do think that the Zondo Commission created a sense of relief. It's now been addressed. So people don't even expect prosecutions, because everybody went to the Zondo Commission, they admitted what happened, they gave evidence, and because people think it happened, then most people think it was addressed, and that prosecution won't follow. I think we have to go back one step further back, and that is, we should never have had a Zondo Commission. We should have had a prosecuting authority that prosecutes those matters, because, I mean, Agritzi gave evidence, and he said he went to the National Prosecuting Authority with the Booysen cases long before the commission started. So we had that. I don't think so. We should really even hope for what would happen in the Zondo Commission. We should just hope that we have a prosecutorial authority and police that will deal with these matters. That's why we in our letters indicate to the police, you know, everybody at Zondo Commission indicated to you that those people way back, this is the reason why there was state capture, because they never dealt with it. But it's repeating itself. So although we have the Zondo Commission, it's repeating itself, and it's repeating itself because we just don't have prosecutions. You know, we all spoke about the amount of money that it cost. I think, what was the last? 900 million or something. It's just an incredible amount of money. And I just think if you used all that money and you had a prosecuting authority that you can trust, that you can appoint people to, and the South African Police Service, you could have made better use of the money. I do agree. It's now in the open, but for me, that's the benchmark, the highlight of the Zondo Commission, that it's in the open.
Gerrie, let's just call a spade a spade. The fact of the matter is, after whatever the result of the Zondo Commission is, and we know what the result will be, then only the work starts. So now all of those perpetrators identified must be prosecuted at best scenario, meaning that investigating officers or teams of investigators must be appointed. Remember, most of the evidence provided at the Zondo Commission was not necessarily entertained or even cross-examined and tested for the weight to be attached to that evidence. So it's not as if we can use that evidence as is merely by presenting it in a court of law in a criminal matter. It must be proven. It must be there must be oral evidence in court. It must be tested by means of cross-examination and corroborating evidence. The principles of our legal system and law of evidence will have to apply. So the work only starts once the report is out. And now we are already halfway through that 20-year term that I've referred to earlier on. It is a big waste of money, if you ask me. I am on par with Gerrie on that one. Not to say that there weren't instances where I actually acknowledged that good work was done, be that as it may, but look at the long-term effect of what we are exercising here.
I think we should a little bit debate this one.
He said it was dangerous.
I don't think there's any basis gainsaying what you've said. I think it's absolutely true that the Zondo Commission is actually nothing but a symptom of failure of 15, 20 years. In other words, up to the time when the Commission was actually appointed. I'm just saying that in the absence of proper work being done by the prosecutorial authority, the police, and so on, eventually, as a result of the fact that we've been maneuvered by a malfunctioning system under the auspices of the ANC into a situation like this, the Zondo Commission was kind of a way out. But I think there's no way of denying that, as you've indicated, that that's actually a system of failure. But we should just see a failure of what? And Chair, if I divert from the point, please tell me to shut up, or just switch this off. It's a failure of the police. It's a failure of the prosecutorial authority. It's also a failure of Parliament, because Parliament is supposed, according to the Constitution, to exercise parliamentary control over the executive. Has that happened? No. It has failed large scale over a very long period. Okay? So in other words, what we are facing here is a systemic failure. It's a systemic failure. Then also, interesting, is it's also an indication of failure of none other than the Constitutional Court itself. I'll tell you why. Back in 2015, I would like to hear your response to this one, and that's not to put you in a difficult position. But back in 2015, it could be 2016, there was the Glenister 3 case. Okay? It related to the disbanding of the Scorpions and its replacement with the Hawks. There were 3 cases. Now, this was the 3rd case in this series. And the applicant in this case, Mr. Glenister, together with a couple of others, argued that you can't have something like the Hawks. Previously, you had the Scorpions, and you had, back in the year 2000, the Heath Special Commission, which was very effective in investigating and prosecuting crime, specifically white-collar crime. Then the ANC wasn't satisfied with the Heath Commission. Why? For a very simple reason. It was effective. It did not want to have an effective crime prevention and combating agency. So it was disbanded. So eventually this matter ended then up in the Constitutional Court, and there was something like 1,000 pages of evidence indicating in a nutshell the following: that you can't have the Hawks falling under the police, because the police is by definition a corrupt institution, falling under a corrupt ministry, falling under a corrupt cabinet, which is part of a and the applicants had a very bad cost order against them. Interestingly, one of the judges presiding in that case was none other than Justice Zondo. So eventually Justice Zondo, 3, 4, 5 years afterwards, was confronted with that amount of evidence that was presented in the Glenister 3 case, multiplied by 10,000. And then he had to listen to everything of that, and suddenly all of that was relevant and not vexatious. So, in other words, we have a vast failure of the system, including also the courts, as attested to by this case.
I'm going to ask Jock if we shouldn't ask if there are questions from the floor before I answer this question, because I can't. The one thing I'll say about what Zondo is confronted with now and what happened to Scorpions is that the methodology adopted by the Scorpions and the methodology that we worked on caused the Zuma prosecution. I mean, the Scorpions investigated Zuma, prosecuted Sheikh, and it's the same team. The investigating officer there is the investigating in the office, in the Scorpions, that investigated the matter. Here, there's Andrew, Chris, and Slung. We were all part of the Celebe prosecution. It's only the methodology used by the Scorpions that allowed that kind of investigation and that kind of method to develop. That and a very strong National Director of Public Prosecutions. So I think it's absolutely brilliant that you pointed out the fact that Zondo is now confronted with exactly, he was part of the majority judgment earlier and is now confronted with it. So that is my answer, that if one even think that the Hawks and the investigating directorate in the national prosecution is the answer to the collapse of the criminal justice system, I surely cannot share that view.
Gentlemen, thank you very much. Time has unfortunately caught up with us, so I'm going to have to open the floor for a few quick questions. Can I ask if you've got a roving mic? Thank you very much. Would you please just be so kind to introduce yourself and also state who you're addressing the question to? That would be great.
Alet Rademeyer from AfriForum. I have a question for anybody. If we accept that the NPA and the judiciary system is captured, we accept it, that it's captured by the ANC. I want to know, do we have, as a country, any other route to go internationally to put light on this matter?
Sorry, I hope I've listened to your question correctly. Is your question, if we accept that the NPA have failed their duties and they are captured, and I think we are all in agreement that that is exactly what it is, do we have something to replace them with? Is that your question from an international perspective?
No, can we take the issue internationally?
Can we take the issue internationally? Okay, I'll start off maybe on this one. There's basically possibly two scenarios that we have seen of late that can play out. The one is the so-called African Court of Criminal Justice or something to that extent. Now, that is a total disaster, if you ask me. I cannot think of one single successful conviction, especially relating to South Africa, that have ended up there successfully. And make no mistake, there are a lot of jurisdictional problems before you can go there. So I've noted with a smile, maybe ironically, some of the former cadres of former President Zuma, inter alia, one of his colleagues, Carl Niehaus, that at one stage suggested that he's going to approach the African court. With all due respect, there's absolutely no merits in that argument because he lacks the jurisdiction. They cannot attend to the matter, simple as that. So that is a going nowhere situation. The other one is the International Court of Criminal Justice in The Hague. I am a member of that organization myself and a defense counsel there. And once again, I do not think this is one of those matters that we can merely take there. Before you can get and end up in The Hague, you need to persuade the prosecutor to have an inquiry, to once again have a report available, and then ultimately decide whether they want to prosecute the matter or not there. And then it must relate to one of those ultimate crimes that is mentioned in the Rome Convention. And I don't necessarily think we are at that stage where we can say that, listen, these are crimes against humanity, necessarily. That depends on your definition of obviously crimes against humanity. We've seen of late crimes, allegations of apartheid and so on that have been declared as such. So to that extent, there is obviously room for discussion and maybe elaboration of the jurisdictional terms of reference. But that's about it. So no, our Concord is our apex court, and we have to sort things out locally in this country amongst ourselves, with the ultimate court being the apex court, which is the Concord. So that is how I see it.
Sorry, perhaps I can just add something. I'm not well aware of the legal position as far as this question is concerned, but there are quite a number of international conventions in terms of which also the South African government, which is a party to them, are bound to take effective action against, amongst others, corruption. So that could not necessarily lead to people being prosecuted. Your charge, so to say, in that case, is not against a specific individual who is not prosecuted, but directly against the South African government, having failed to uphold their international obligations in terms of those international treaties. In another Glenister case, Glenister 2, the majority judgment in that case, for some inexplicable reason, that's not the only cases I've read, okay, but I tend to remember that. The majority judgment in that case went into considerable detail into South Africa's international obligations in that particular field. So I think we can make use of expertise in that particular field, people like Advocate Toy, Henny Strydom, and so on, which can be put to good use in order not so much, as I've said, to prosecute, but to really put this government in a very, very bad position in relation to upholding the international obligations. And just lastly, I think you guys, after the Zondo Commission, will have an absolute field day, because then you'll have to control, not only to exercise checks and balances, not only over the Zondo Commission, but the consequences of that. Have prosecutions been undertaken? Obviously, the office will have to be enlarged.
No, I don't think we need to appoint more people. I just think we need a couple of people to start working. But you're 100% correct. I mean, that is our next focus. Our next focus is, by arresting Agritzi and prosecuting Agritzi, what happened to all those allegations against cabinet ministers? Have you now silenced the evidence because you can't use it? And that's where we come in. That is our approach to whatever is happening, saying that you cannot prosecute your whistleblower and your witness in other matters and try and absolve those people. So, but I'm just talking about Agritzi, but there's lots and lots of other matters, and you're 100% correct. I do think that what will flow from the Zondo Commission, not so much of the prosecutions, but the failures to prosecute, that we will get involved in.
Do we have any more questions? Mark.
My name is Mark Oppenheimer for the Johannesburg Bar. My question is for Gerrie. You've sketched out the promise of private prosecutions, and I wonder how far you can take that private project. So we have a parallel system with regards to the civil law. So you can appoint a private arbitrator to resolve your dispute. Should we be doing that with criminal justice as well. So having private courts, private prisons, private prosecutions, and if so, how do we prevent that system from turning into a kangaroo court, where you've got a parallel system of justice that's going, running differently from the state, but you can feel that it is actually a sense of justice, not just vigilantism?
Yes, Mark, what I perceive a prosecution authority or private prosecution authority, if you establish a private prosecution authority, you still have to use the criminal courts. I have not perceived, or I have not given thought of private courts, private magistrates, because you do need at that venture where you prosecute somebody and somebody's convicted, you need the prisons. You can't create courts, prisons, and a whole justice system. So what we're focusing on is merely prosecuting the matters, and that will ensure that matters get to court, and that will also ensure that people get prosecuted that are sheltered from prosecution because of the other kangaroo court. Because if you talk about kangaroo courts for private prosecution, isn't it the same kangaroo court for people that do not prosecute and prosecute different people? So, Mark, in the way that I perceive this is not like in civil law, where you have a panel of judges just dealing with particular matters. I'm perceiving more a prosecutorial authority that will prosecute matters in the normal courts with the normal appeals and the normal prisons to follow.
Thank you, maybe I can also intervene here. Yes, I totally agree. I do not think and anticipate that we will ever get to a stage where we'll have a comparative to the civil system where you can pick and choose your presiding officers randomly by means of equivalent to a mediation process or arbitration process even. That will not suffice. Otherwise, you will have an issue with the independence of the so-called presiding officer. Just to give a simple example, whenever you are prosecuted and stand trial for a transgression, the first thing that will come out is you're going to object against the presiding officer for being biased for whatever reason. You will delve into his history to find something to get rid of the presiding officer. So that will never fly. And it's totally against any international standard, any constitution that I'm aware of that is regarded as a first world country's constitution. So do not confuse the civil litigation and civil options available to that of criminal cases. That's the one thing. What I am in favor of is maybe the expansion of a situation that Gerrie alluded to give more power or more leniency to have more private prosecutions to expedite the proceedings, to get them sooner into a criminal court before a presiding officer. That can work, definitely. A second possibility is to ensure that our presiding officers are specialists in their field. We see it in our regional courts on a daily basis, especially in our special commercial crime courts. Those magistrates presiding there have years of experience, decades of experience, 20, 30, 40 years sitting on the bench doing those cases predominantly. So they can cut to the chase. They can expedite proceedings. They get to finality in a matter within days. Some of these matters, some of them, my colleague have been involved with himself, are run-of-the-mill murder trials that gets prosecuted in the regional courts on a daily basis. It should not take 3, 4, 5 years for a murder trial to be finalized. They finalize those matters in the auspices of 2 weeks to a month. Done and dusted, and maybe there's an appeal process of another couple of months, but that's about it. So we should maybe ensure that we have judges specializing in criminal law for a start, because I get the feeling these days that some of our aspirant judges, even our acting judges, they know the civil law, but they're not specialists in criminal litigation. So that ensure that a trial extends for months on end instead of getting finalized within a couple of days. So that is a possibility. I'm all in favor of specialists on the various fields, and even in the auspices then of offences. We might even have a situation where certain judges specialize exclusively in corruption matters or fraud matters, for all I know. So there might be a difference in the approach that we perceive here.
Mark, I think it's a very good question. And, you know, if I've only succeeded today in letting people think about this and to assist us in developing something like this, then I've succeeded. But to answer your question, as far as the abuse of this process is concerned, because if you refer to a kangaroo court, that's really the abuse of a private prosecution authority. There will always be checks and balances, and cost orders will always be the checks and balances, as you have in civil litigation. It's always a cost order that ensures that you don't, that it doesn't develop into a kangaroo court, as you call it.
Sorry, can I just also add one or two things here? In most of these cases, which are criminal cases, obviously, it's also delicts. And to that extent, they are civil matters. And even though one would like to see these criminals being prosecuted, I think often there's a possibility, and through resourceful thinking and strategies, I think which we should be embarking upon, I think eventually with much more ease, one can eventually end these cases up in the civil court much easier than in the criminal court.
Thank you. I'm going to give one last opportunity for a question, if there is.
My name is Charles Mawa. I'm from the Netherlands Embassy. Maybe just one for me to walk away with a little bit of hope. If one is to look for hope, where do you find it? I mean, the idea of private prosecution could be an example of initiatives where one can find hope, but you still have to work with other elements of the justice system, which, as the presentations have demonstrated, are equally limbing. So within the system, are there any sparkles that you can point us to and say, if you are looking for hope, there is some hope here? Thank you.
I'll start off, and maybe my colleagues can add.
Llewelyn. Sorry, Kali just wants to add something to the question, and then we can finish off.
Thank you so much. I want to thank the representative from the Netherlands Embassy, because if I listened to all this, it was enough to drive me to tears. But fortunately, I had a hanky, and fortunately, tears dry quickly. But if we're looking for hope, I think the bigger danger than tears is if one becomes despondent. And sommer in goeie Afrikaans as jy moedeloos raak. Because if you become despondent, then you get to that old cliche where good men and women do nothing and then evil will prevail. And this is just to add on that. You know, I've been privileged to follow this with Advocate Gerrie and his team. And what gives me a hope is the large number of cases where there has been success. You know, we've heard about what happened in Dwarskersbos and in Umhlanga, where the police victimized people. We even had a father that had to go for baby formula milk that was bullied by the police. And that gives me hope because you can never accuse Advocate Nel and his great team that they become despondent. They remain vigilant. The wheels of justice don't always turn as quick as you want them to turn. But by remaining vigilant and not giving up, we've seen successes in those cases. The same is with regard to a number of rape cases and even a murder case where nothing happened because you had the bulldog not giving up and just continued not releasing the bite. We've seen a number of those people that eventually got to court. And then in some cases where you didn't get them to court, we had the Tande Modisi case and the Alexi Bisos that allegedly broke 6 of his wife's ribs. there will be justice for Monique van Oosterhout, who was assaulted by, allegedly, let me say that, I've been taken on, allegedly assaulted by Alexi Bisos. And that case is coming. Even if you then go further with the Tane Modisi case, where the Magistrates Court dismally failed in terms of the interpretation, you still then just have to remain vigilant and then take it on appeal. And our experience in AfriForum in a number of other cases, you just have to keep on going. And that was a long way to say that's where I get my hope. And I actually want to thank Advocate Nella and his team. And I'm very objective, of course, with regard to what the work AfriForum is doing. But those are the things that can give us hope. Of course, it should not take decades. Of course, it should happen quicker. But the second alternative is to just never give up and get the wheels of justice turning, even not as fast as we wanted, but the wheels of justice are still turning, and that is because there's a private alternative.
Thank you, Gerrie. Llewelyn.
Thank you. How do you eat an elephant? One bite at a time. So it starts obviously with the little things. I have referred to in my paper as well as to the fact that any justice system can be revived. Obviously, the first point of departure would be during an election. So if you're not satisfied with the people representing you and for people not doing their job, get them out of the seats. That is the first priority. So obviously that's the right answer. But from a realistic point of view, going forward, I would assume that the other possibilities are also there to explore. I like the idea, whenever there's something untoward or wrong, expose it, and ultimately take it to the courts, because people only feel it when it reaches their own pocket. So the more cost orders we can get to those individuals responsible for not doing their job, and I'm talking about public officials, and where they have to pay it from their own pockets, not from taxpayers' money, that will, to a large extent, assist in them doing their jobs as well. That's the second option. Obviously, going forward, I like the idea of more private prosecutions, because that exposes those individuals in the NPA that's not prepared to do their work properly. One can explore those. And lo and behold, at the end of the day, the media, seminars like this, the word must go out. People must be put on terms for doing their job. So there are definitely positives that we can take from this. It's not the end of the road. Maybe my colleagues have other possible avenues to pursue as well, or options available and recommendations. But as far as I can see it, there's definitely hope, and I've tried to allude to some of the possible avenues and to resolve the issue in my paper as well.
So from our point of view, which is more practical, I still do have trust in the Supreme Court of Appeal. The Supreme Court of Appeal is the highest court for criminal matters. I'm just a criminal lawyer, only practice in criminal law. So sitting where I'm sitting, I still have trust in the Supreme Court of Appeal as we stand today. So when we start a matter and when we approach a matter, we approach the matter and we conduct the prosecution in such a way that if we're not successful here, we will be successful in the next tier of appeal or the tier of appeal after that. So for what we have currently, that is our hope. Our hope is if we do everything we can, if we follow the laws, we understand it, whatever happens at the court of first instance, there's always an appeal process that we can follow. And currently, I do think that when you get to the SCA, which is in Bloemfontein, you will get justice. And I'm just referring to criminal matters, because that is what I practice in.
Sorry, Koos, before you answer, Gerrie actually referred me to something that I wanted to mention as well. I think the first step is to ensure that whoever gets appointed to our bench are the best lawyers out there. Politics should not play a role. We should appoint the best judges on the bench because they will ensure that the rule of law is applied. That is the way it's conducted all over the world, and why should we be the exception to the rule? But as long as we have political interference with especially the appointment of our bench, and I'm now referring to the highest courts. So at this stage, we are satisfied with the SCA and the members and even some of the Concord judges, if not all of them. I will not point fingers. But the fact of the matter is it's deteriorating. Lo and behold, we cannot sit with judges on the bench that have less than 10 years experience in practice, etc. That's just not on. Because ultimately, the law will then be disregarded. And as long as we have the best judges available, then there's definitely hope.
Prof. Malan, any closing comments? Are you happy? Okay. Well, on that note, I would like to thank our panel for sharing their insights today. It was a very good talk. Thank you very much for your time. And thank you very much, everybody, for attending. Lunch will be served shortly outside in the foyer. Thank you.